Good afternoon. Welcome to the Appellate Division First Department. We have some almost 6.5 hours of argument time requested this afternoon, so please bear that in mind as I call the calendar, and remember to ask only for the time that you absolutely need to make your most important arguments. Today, we have a class with us, about 18 students from New York Law School, led by Professor Singh, I understand. Okay, well, welcome here. We're glad to have you. We hope that you find this argument this afternoon interesting, and you learn something from it. And I hope that you're not discouraged by anything you see here today. So, with that, I will call the calendar. People versus Emmett Allen. I'll give you 5 and 2 and 5. Thank you. Tevlin versus Tevlin. Submitted. Doman Holding versus Sanders.
Appellant requests 6 and 2. Respondent requests 5.
5 and 2 and 5. Thank you. People versus Richard Butts. Submitted. Kim versus, forgive me on the pronunciation, Badu or Badeau.
Appellant requests 6 and 2. Respondent Bedway requests
Bedway.
8.
6 and 2 and 6. Salomon versus Dealey Glastetter. 5, 2, and 5. Thank you. People versus Londell Squire. Submitted. Bank of New York versus Bosboom.
Respondent would like 5. I don't know if I should object. They didn't put in a reply brief. I'm not sure if they're...
Well, you don't have to put in a reply brief. You just have to put in your brief. Reply is up to you. So,
I'm saying I'm objecting.
right, yes, I understand. You put in a brief and not a reply, but they did not put in a reply brief. Okay, no, yeah. 5, 2, and 5. Bridgerton versus High Rise. 6 and 1 and 5. JS versus City of New York. 5, 2, and 5. Thank you. People versus Luis Gonzalez. 5, 2, and 5. Thank you. South 32 Chile versus Sumitomo Metal.
Appellant requests 8 and 2, Your Honor. Respondent 6 minutes.
Give you 6 and 2 and 6. We'll take it from there if you need more time. Verdugo versus Smiley and Smiley. 5, 2, and 5. Thank you. 5 Star versus Trustees of Columbia. 5, 2, 2, and 3. Thank you. Bison Capital versus Hunton and Williams.
Yes, Your Honor. Appellant requests 8 and 2.
There's a cross appeal here. Did you want 5, 2, 5, and 1? People versus Nilik Hill is submitted. Sawyer versus 1120 Fifth Avenue Corp. is submitted. First case for argument is People versus Emmett Allen.
Good afternoon, Your Honors. Jan Hoth for Appellate Emmett Allen. Defense counsel's purported reason for not consulting with and hiring an expert in order to challenge Mr. Allen's BAC reading cannot be considered objectively reasonable.
Why wasn't that considered objectively reasonable? Counsel's strategy was she did speak with an expert with regard to the breathalyzer before. Maybe you can hear me. She did speak with an expert before she went to trial. She did cross-examine the officer, and she did use the video to defend her client. Why wasn't that meaningful representation?
Well, it's entirely unclear what expert, who expert she spoke to. She couldn't remember a name. All she could remember. Excuse me?
Didn't she say the name Brown?
No, she offered counsel below on the motion papers a name, but she wasn't sure. And at the hearing, she just had no recollection at all. Her recollection was limited to that she knew she had not, if she had consulted with an expert, she had not sent them the video.
Well, she still had a robust cross-examination of the officer and used the video, one might say effectively, given that I believe the charges, there was only a conviction on one of the charges.
Well, Your Honor, as the court noted even before the trial started, Mr. Allen did not appear extremely intoxicated on the IDTU video. However, the court remarked and warned defense counsel that the .24 blow was a killer, and it saw no way Mr. Allen was going to be acquitted of that.
Either way, expert, no expert, anything. That was the court's opinion.
That was his opinion, and her response to this was that she was going to argue that the machine was wrong simply because on the video, Mr. Allen did not display indicia of extreme intoxication. But she also admitted that she was aware the court would be charging the jury that in New York State, the Intoxilyzer 5000 EN is considered a reliable instrument for measuring a person's blood alcohol content. So, and the court charged the jury that numerous times during her, air quote, robust cross-examination. So what did she actually gain by that? Nothing. She had a video where her client does not appear extremely intoxicated. But now you have a machine giving what the court is going to instruct the jury, a reliable BAC. Why would the jury reject that simply because she says it's wrong? She says science is an absolute. Give the jury a basis. If she had presented an expert who would have testified that, given the multiple exhalations that Mr. Allen submitted into this machine, no air blanks, no changing of the mouthpiece, the result was contaminated. Now you've got something the jury can work with.
Unless that's not what an expert would have testified to. You haven't established that that's what an expert would have testified to, and it's not at all clear that the repeated blows were necessarily the problem.
I'm sorry, Your Honor, I disagree. Dr. LaBianca was quite insistent that NYPD protocols require during calibration and maintenance that air blanks be used to make sure that all preceding air is blown out of the tube. He was further adamant that the number of failed exhalations, meaning that Mr. Allen was blowing into the machine and the tone goes and it stops when it's done, he just kept stopping.
I thought he said, LaBianca, that simply that the slope detector was not foolproof, but he also said that he couldn't quantify why the result was suspect and that no scientific literature had supported his hypothesis.
Yes, but Dr. LaBianca was still adamant that once you've blown into the machine, their residual vapors, alcoholic vapors, are going to remain, and a subsequent blow might push out the air, but it's clear from the NYPD protocols it's not pushing out all of the air. or they wouldn't use air blanks at all. There'd be no need for them.
Except, okay, I'll ask you later. Thank you.
Good afternoon, Your Honors. Hunter Barron for the people.
Why don't we start with Dr. LaBianca where we left off?
Absolutely, Your Honor.
Why doesn't that show that there was an issue here in the kind of representation that the defendant got?
Sure, Your Honor. So Justice Paik, in her 440 decision, explained that, well, the first problem with LaBianca's testimony, it was completely untested, this hypothesis about contamination. He couldn't point to a single academic or otherwise publication that verified this type of hypothesis, and he couldn't point to exactly, even if the hypothesis had merit, what magnitude it would affect the intoxilizer result. But that, Your Honor, is just the prejudice prong. Of course, I don't think in this case we even get to that stage because counsel provided more than adequate, effective representation in this case, vigorously cross-examined the people's witnesses, and in fact obtained an acquittal on one of the charges. So unless Your Honors have further questions about.
Didn't she get Officer Outlaw to acknowledge the possibility of improper calibration during her cross-examination?
I think she was able to get Outlaw to acknowledge that ultimately the calibration was done by a human person, and that was, as a result, subject to human error. So that's my recollection. So unless Your Honor. That's right, Your Honor. Her strategy was to undermine the intoxilizer using the video and cross-examination, and as part of that strategy, she did not see an expert as a necessary component. So unless Your Honors have further questions, thank you.
You had a question?
It's been answered. It's okay. Thank you.
Okay. I want to say that she did not get, defense counsel did not get Officer Outlaw to say that there was a problem with the calibration. He didn't do the calibration.
Cross-examination got nothing from her.
What she did obtain out of cross-examination was that he never changed the breathing tube. But she never connected the lack of changing a breathing tube with possible contamination, which is what we're saying. That falls right in with what Dr. LaBianca was saying. That
Dr. LaBianca also said that wasn't quantifiable, what difference that would make, correct?
he was unable to quantify the amount of contamination, but he was adamant that contamination existed. So if
So it could have been quantification, it could have been 0.23 instead of 0.24.
Yeah, but isn't the point that it's a contaminated result? So why would you give the jury simply, well, he doesn't appear that drunk on the video, when you can give the jury, well, he doesn't appear that drunk on the video, and his BAC reading was contaminated? That gives the jury a reason to acquit. He doesn't appear that drunk on the video, fine. So they acquit him of the count that requires visible signs of intoxication. The statutory per se, if you blow over 0.08, you're considered intoxicated. Why would they reject that? Simply because she's saying the machine is wrong. The court's telling them the machine's reliable. The court is telling them that the operator is reliable. The people put in all sorts of required documents to prove that this machine had been maintained and calibrated according to NYPD protocols. Outlaw wasn't even responsible for that. He had no way of knowing. All he can have is the reports that say everything's working the way it should. She did get him to admit that he wasn't aware of the temperature. However, on redirect, the prosecution also got him to admit that the temperature was wrong, the machine wouldn't work. So she accomplished nothing with that. She accomplished nothing with, she established no change of the breathing tube, but didn't connect it to anything. She established he didn't know the temperature, but that was debunked because the machine would have stopped working if the temperature was wrong. So basically, she was asking the jury to say, look at this video, and I'm telling you the machine is wrong. And that's just not effective representation.
Thank you. Thank you both. Doman Holding versus Sanders?
Good afternoon. I know that this
You
bench
have to
has
give your
already read
appearance.
the record.
Note your appearance, please.
Oh, Robert Grimble of Grimble and LeJudas LLP, 217 Broadway, New York, New York, 1-207-212-349-0450.
Thank you.
I'm sorry.
Okay. So let me ask you, because you had to pause. You're challenging fraud claims here. I'd like to know how the plaintiff failed to plead fraud with sufficient particularity where the detailed allegations about your client's active concealment of the defendant's death.
Well, there's at least 3 points there. One, with the pleading about active concealment, that is all in a conclusory fashion. It's well-written, I agree, it's very articulate, but reading it, you don't know exactly what they are saying that Mr. Sanders did. That's one thing. Second thing, a major
Well,
element...
they're saying, for example, that the person whose name the apartment was in had died almost a year before, or some close to that, before he said that she was dead. He said things that suggested she was alive. In fact, he sent checks in her name when she was dead. I mean, that seems pretty obvious.
Well,
And to add to that, he said she was in rehab and he was taking her every morning and bringing her back, and all the while she was dead.
actually, if you read the complaint carefully and you read the affidavits, that's not what they say. They do not say that he made that representation after she had died. She was in the rehabilitation facility because of a stroke and because of Alzheimer's.
I think what was said. Sorry. I think what was said was that she was in rehab and there was no intention for her to come back to the apartment. So
That is what the plaintiff and respondent is claiming here. It is not otherwise evidenced by anything other than their conclusory statement. But getting back to your initial question as to
But during the
fraud,
time he
where
was
is their
saying-
reliance?
During the time that he was saying he was taking her to and from home every day to go to the facility, she was actually living at the facility, right?
She was staying in the facility.
Right, so the statements he made to the effect that he was taking her from the apartment to the facility every day were false, correct?
Well, he says he didn't say that he was taking her there. Okay. And not only that, the fact that, can you say that the landlord justifiably relied on that in a doorman building, not seeing her coming in and out?
I think they said they
reliance has
had
to be
limited.
Justified.
I think there was limited.
They only had a part-time.
It was a part-time doorman, so there was limited kind of doorman activity, as you put it.
Well, the landlord does not say what the hours of the doorman were, and there's no affidavit from the doorman as to what they saw or what they believe. But again, getting back to your question, one of the real problems with the fraud is reliance and damages. Those are two major elements. What are the damages? Because
Damages are that they were going to, they applied for the scree benefits where they would not have applied for them if they knew she was alive.
however,
And that they may
however,
potentially be on the hook for them. They're clearly alleged
Well,
damages.
however, Your Honor, the scree benefits, of course, they are only pulled when it's recertification time, no matter what. That's just the policy.
Right, but if they knew that she was dead, they would have notified that they were no longer eligible for those benefits. That's what they alleged, it's a motion to
Well,
dismiss.
the other major point of that is that the scree benefits don't change the amount of rent the landlord is entitled to receive. The scree benefits are a subsidy to the tenant. The landlord is entitled to get the same amount of money, scree benefits or no scree benefits.
Right, but
Whether
if
it comes,
if he continues to get scree benefits when he's not entitled to them, he then has to repay that.
well, or the estate does. Yes. He does not have to because the case law is very clear that until he's recognized as a tenant, he doesn't know any rent. But even if he,
don't know what
but
recovery-
even if he does have to pay
We
it,
don't know yet what recovery there is or is not going to be from the estate. Right now, damages were alleged.
well,
Motion dismissed.
On the declaratory judgment, is there any documentary evidence that your client would be entitled to succession rights?
yes. Yes. Okay. Well, what you need for the succession rights is co-residency, in this case for 1 year because they're both senior citizens, and a family relationship or quasi-family
And
relationship.
what documentary evidence is there
Of
of
a
a family
quasi-
relationship?
Quasi-family relationship, joint checking account, power of attorney being named by the surrogate's court as the spouse, being listed on the death certificate as the spouse.
Well, but that doesn't do you much good because the death certificate says at the bottom that the Department of Health does not certify the truth of those statements.
Well, that is true that is not conclusory evidence. However, the evidence you have in there, the complaint and the affidavit say that they lived together for a long time. You have a joint checking account. You have the landlord's own statement.
It says they
that
lived
he-
in the apartment, doesn't say that they were intimate partners, just that he was a roommate.
Anyway, I'll let you finish up
What I'm
on
saying
rebuttal.
is, there's a joint checking account there.
Thank you.
This is what, I mean, the papers.
I'll have you finish up on rebuttal.
Oh,
Thank
I'm
you.
sorry,
I understand.
Good afternoon. May it please the court. Adam Pollack, representing the plaintiff respondent, Doman Holding Co. As your honors clearly seem to know, this is an interlocutory appeal. It's a denial of appellant's pre-answer motion to dismiss the complaint. I believe that the lower court got this right, respectfully. They applied, Judge Knock applied the correct standard of review.
When did Mr. Sanders let the landlord know that she passed away?
March of 2024. And she had passed away 13 months previously. And that was the first time the landlord or its managing agent had any notification.
And that was because you were still getting checks signed by her.
Her name on the upper left-hand corner of the check and the lower right, apparently her signature.
Were there any checks submitted that showed joint checking account for these two people?
Appellant below, years ago, showed that there were joint checks paid, but respectfully, Your Honor, we're not here on a summary judgment motion. We're here to measure the adequacy of the pleadings and whether, if you construe them with most favorable interpretation, does my client not have a cause of action? That's the burden of proof, and respectfully, the appellant didn't make it below. Judge Knock basically said, we've been here arguing about facts the whole time during argument, and that's the transcript before you. Essentially, that's what I hear in the argument during appellant's time before you.
Go back to the checks. He
Yes.
kept paying with her checks and her
Someone did.
signature.
Someone did.
Someone.
For 9 months.
And then they went to bank checks.
For that, we got notification from the bank saying checks dishonored, with same account, presumably the account we've got from the same tenant for 30 years. Check dishonored, go speak to the maker of the check. At this point, the maker of the check is 10 months deceased. We had been looking for her and trying to find her, it's in the record.
And then another check is submitted where the address is whited out.
Well, then we get teller's checks, which teller's checks are just from the bank. So we have those 3 teller's checks. One of our causes of action is, please, Supreme Court, tell us what to do with them. We don't know who remits them, okay? And then we get checks from appellant's client saying, I'm entitled to succession rights, and automatically you should take them. And if you don't, it's to your trepidation.
But for the rent that was submitted, after she died, there was never a check given with a joint account showing both Mr. Sanders and the deceased.
Not in this record.
Thank
No.
you.
And each payment was made as if the discrete benefits should still apply, which are contingent upon Mr. Ronovich being alive, and she was not. So I believe unless there's any other questions,
I think we have your position. I think we have your position. The case should survive.
okay. Thank you, Your Honor.
In response to questions and comments about the joint checking account, beginning at approximately record 43, there are a series of joint checks from 2020 through 2022 that were tendered and accepted for rent. So these extend far beyond 1 year before Ms. Aronovich went into a nursing home and more than 1 year prior to her death. So you certainly have that relationship in terms of the family issues.
But that doesn't establish a familial relationship. There are lots of reasons people can have a shared bank account apart from being a family. Apart from the bank account, what other evidence do you have that they had a familial relationship?
Power of attorney. We have the power of
Again,
attorney.
that's some, people have powers of attorney over family, friends, or other people. Apart from those two things, is there any other evidence? Any letters, any pictures of them at happy gatherings together, anything else?
It's certainly not in the record, other than, of course, the landlord reaching out to Mr. Sanders for access to the apartment, which is the sort of thing that one would do to a companion of a tenant or a spouse of it.
Or a roommate,
but
or
if
a
you,
roommate.
A
One would
roommate.
also do that as to a roommate.
you could do that as a, yes, but again, and I'm not saying that had this case been properly commenced in civil court with the appropriate predicate notices.
You haven't established that it was improperly commenced in Supreme Court. Supreme Court is a court of general jurisdiction.
It is indeed. However, it's brought as a declaratory judgment action, and there are a plethora of cases, including a number of cases from this bench or from this court that say that if you can get a full remedy in an eviction proceeding in civil court, that is where you should bring it. And there also have to be, and it's the Hughes case, that there have to be predicate notices. There are no predicate notices here. But as to the familial relationship, I didn't expect that that would be determined on this motion. There's enough proof there that it shows that we have a very significantly strong case.
So then
However,
you'll continue with the case below then, if you believe you have a strong case on those issues.
yes, however, I
Thank you.
suggest that this really belongs in housing court, because the housing court is a preferred forum for matters such as this.
I don't think it would be the first time that the Supreme Court dealt with this issue. Thank you very much. Thank you both.
Thank you.
Kim versus Boudouet, I'm sorry.
Right away.
Bedouet. Bedouet? Good. Forgive my pronunciation. Bedouet. Okay.
May it please the court, I'm Robert Greener from Law Office of Robert L. Greener, PC, and I'm here on behalf of appellants. It is appellant's position that the lower court erred by not deciding at the summary judgment level that the PCA, post-closing agreement, damages provision as a matter of law was not improper or unlawful.
Why wasn't it an enforceable penalty, an unenforceable penalty?
I'm sorry, could you repeat the question?
Why wasn't the liquidated damages an unenforceable penalty?
Why wasn't? Oh, for the very simple reason that the damages provision was reasonably proportional to the anticipated damages that the appellants would receive or incur if the holdover period continued. Incumbent within those, the $600 amount, and I have to point out that base rent and holdover rent are terms that are used by opposing counsel. They don't actually appear in the PCA agreement. There was an initial occupancy fee for 30 days, and if the Mr. Bedouet did not vacate, then there was a $600 a day penalty for his remaining in the apartment. That
Was this penalty, was it at a point where it was beyond the limit? I mean, it's about 2 to 3 times higher than the rent? Was that appropriate?
in the court, I'm sure your honors are familiar with Seymour versus Hanoverian. In that case, the court held at a 2.3 times multiplier was proportional. What we have to look at is the underlying basis to where that number comes from. What was not included in opposing counsel's argument to the court and below is that that number comprised in a completely different apartment to which the appellants had to maintain for that additional time period. That's number one. And the cost of that apartment, and the statements are within the record, was equal to what the cost of the current apartment was that they wanted to obtain possession of. The second thing that it included was the fact that they couldn't get use and occupancy of the apartment during the time that they needed to come in and repair it so they can put the first apartment up for sale. And then the other factors that went into it, which, remember, we got what the court said in the Seymour case is that, you know, hindsight's 20/20. We have to look at what was anticipated at the time of the entry to the agreement. There was no idea as to when he could or would vacate. Excuse me.
Over $9,000 and seeking about $18,000, so only twice what the out-of-pocket cost would be.
Well, yes and no. There was double the amount of the actual cost, which is they had to pay for the maintenance. And the other thing was the legal fees and costs associated. There was no understanding at the time how long this residency period could go. It's entirely possible that he could have stayed 3 or 4 months, which case my clients would have to continue not only paying for 2 apartments, but lose the opportunity during the lucrative spring selling season of being able to sell the apartment and then get rid of that obligation. So all of these things were factored in, and they're reasonably related, like in Seymour versus Hanoverian, where the damages related to the potential of the tenants either not renewing their lease or not paying rent and vacating. So that was kind of like speculative, and the court said, even though it might be a little speculative, and in the end the tenants did not vacate, it was still reasonably related to the situation at the time they entered into the agreement and was a possible damage. So, you know, while the numbers itself is, you know, as a multiplier of 2, but it didn't incorporate all the other factors such as loss of use and occupancy. Yes. No, Mr. Romano, not the current counsel here today.
The person
was a
who drafted it was a very close, trusted advisor of Mr. Bedouet.
Yes, and in fact, Mr. Bedouet said that, you know, he didn't really need to read the agreement because it was, he trusted his lawyer implicitly to do whatever he was going
And
to
it was
do.
he who asked for the PCA.
I'm sorry?
It was he who asked for the PCA to
Yes,
be drafted.
it was he who asked for, and it was he who drafted it. My
Thank you.
client actually wanted possession. They didn't necessarily agree initially to this holdover period. They didn't force the respondent to stay. They wanted him out. So, you know, it was respondent who insisted on it, as the affirmation of Mr. Novar says, as a condition of closing. And second, it was also he who decided to stay. He had options. He made, I think, $1.5 million net profit in this. He had options. He didn't have to choose $600 a day option, but he
Could
chose.
have put everything in storage and stayed in a hotel.
Exactly. He could have put everything in storage and left. He chose the more expensive option, and then he claims that he had no other choice when he had months of knowledge that he had to leave. And then I just want to point out, Your Honor, unless you have any further questions, that there had been no documentation submitted in this entire case we asked for and was never submitted. Any proof that the respondent lost the apartments? There was never any proof that he even had the apartment, such as leases, emails, cancel checks, application forms, application fees, none.
Thank you.
Completely self-serving. Thank you, Your Honor.
Thank you.
May it please the court, Tom Zotilli of Lebelski and Associates for Respondent Bedouet. The lower court's ruling that tribal issues of fact exist as to whether the PCA's holdover provision constituted an unenforceable penalty should be affirmed or alternatively reversed in response.
Why is this an unenforceable penalty? Counsel has referred to Seymour, where the court indicated that 2 to 3 times penalty would, 2 to 3 times the amount would not be a penalty. Here, it was only 2 times, and your client was adamant. He had months to vacate the apartment, and he just stayed in the apartment. He asked for the PCA, and he just let the terms pass. There was no cooperation here. He stayed because he felt like staying. And so why is this now a penalty?
Sure. So to distinguish Hoopnanian in a couple of ways. First of all, here the holdover rent, Your Honor, was $600 per month, which was actually per day rather, which was 3 times the base rent, which the agreement actually terms it as a holdover rent. Just
Isn't holding that that is appropriate, though, at the case cited by counsel?
that is only and just to distinguish Hoopnanian, one more point, Your Honor. The liquidated damages clause in Hoopnanian concerned a contract where there was an 18-month occupancy period for extensive repairs to the to Seymour's apartment.
Right, but in this case, it's an unusual situation. Normally, sellers don't get to stay after the closing. They were basically doing a favor, letting there be an extension. As a norm, most people have to be out by the time of the closing. So under those circumstances where everything was contingent for them to move out, why wasn't that a reasonable amount?
I just want to address that first point, Your Honor, because the damage is here. In Seymour, we were looking 18 months down the road. Liquidated damages provisions are often used to look far into the future where the potential
they had
loss...
no-
They agreed that they could stay for 30 days. It was never an intention that they would stay later than 30 days. It was your client who made the decision not to honor the agreement and to stay. So I'm not sure how your client can argue
Right.
that that's not an enforceable provision.
But
Not to mention your client's attorney, who he trusted. He wrote the document. He wrote the PCA.
I would just
And
like
not to mention that your client has an MBA and presumably knew how to read the documents.
Sure. I would just like to actually answer these questions. The amount of loss that the apartment owners could sustain or expected that they would sustain was an actually calculable amount. That's not appropriate for a liquidated damages provision. Liquidated damages are used when the loss to be sustained is not susceptible to reasonable calculation.
There are
Now,
lots of different
Mr.
ways to calculate it. One can also calculate the loss to the in this case the sellers of the not having access to the apartment.
Mr. Choi,
Sorry, the
his
buyers.
deposition said when calculating the holdover rent, that was principally tied to his mortgage payments for this apartment, which was for $6,000 per month. That was their loss expected.
Carrying the cost on the other apartment, he was held up on renovating the other apartment. So there were a multitude of factors in play here. It wasn't just the cost of this apartment.
That's double dipping, though. They would have had to sustain those losses. They would have had to do those renovations anyway, whether my client had held over or not. And one more point I'd like to raise is that they affirmatively allege in their verified complaint that this is a penalty. You can't, as a matter of basic equity, you can't call it a penalty in your pleading and say it's not.
Why wouldn't that be for the court to decide whether it's a penalty or a valid liquidated damages? That's what courts do.
I'm sorry, I couldn't hear the first.
Wouldn't it be for the court to decide that issue?
It is for the court to decide, but take their...
It doesn't matter what they call it, it's for us to decide.
It is for the court to decide, but what they thought does matter, and what they thought was their actual damages out of pocket were $6,000 per month, and they reasonably calculated their damages to be $6,000 per month. Later, they decided that it should be some higher number. That's not the case. When the damages are reasonably identifiable, you cannot then multiply it by whatever you want.
So you argue that it's unconscionable. Was there a disparity in the bargaining power here when this was drafted?
There was a disparity to the extent that my client was under the proverbial gun. He had
Under the
kids. He had-
proverbial gun,
Yes.
your client,
My,
Yeah,
yes.
your client
$1.5
could
million
have, let me just finish my question, please. Your client, as has been pointed out by the justice, had the option to leave that apartment, to put their things in storage, to go to a hotel or elsewhere. Money was not the issue there. Your client had the opportunity to say, I don't want to do a PCA or anything else, and come up with some other idea. Your client had his attorney, who he trusted, prepare this document, and then violated it.
So Mr. Romano, who prepared the document, was just the closing attorney. I don't know the extent of any relationship beyond that. And beyond that, to the extent that's not clear
Well,
from
it's
the
in the
documents.
record.
He had, my client Bedway had kids in the apartment that he didn't want to uproot. That was an issue. I think we raised that in our brief.
There are always, very often, children, and sometimes they're happier in a nice hotel. Thank you very much.
Unless your honors have any questions, I have nothing further to add.
Thank you.
Thank you.
Thank you both. Salamone versus Dealey and Glastetter. Sorry.
Good afternoon,
Just
Your
a
Honors.
moment, please.
Leonard Lesser.
Just a moment, please.
Please. Thank you. Good afternoon. Leonard Lesser of Simon Lesser for the plaintiff and the appellant. We're here on an appeal of a motion to...
Ask a question starting backwards. I'm going to ask you to start with the damages issue. Assuming that this forbearance agreement was not possible, why wasn't this plaintiff made whole? Because plaintiff got a judgment for the full amount of the loan and the interest and the attorney's fees. Why didn't that make the plaintiff whole in this matter?
Thank you, Justice Kirk. Well, the plaintiff may have been made whole on the original demand note, but he got nothing under the forbearance agreement, which is the agreement that controlled that the defendants drafted to deal with the $300,000 additional consideration for the loss of the value of his
But
Apple
that
stock.
was something he wasn't entitled to get under the law.
That's not true, Your Honor. We allege this, but for the defendant's negligence, he would have been able to enforce
Counsel,
it.
how could he, given the problem with the forbearance agreement being usurious, how could your client have how could the lawyer have drafted this in a way that would permit your client to have received the $300,000 and not run into the problem of the usuriousness?
I'll answer that question, reminding the court this is a motion to dismiss. But what the record will show is there was a very simple way for him to do that, and that is the borrower, the corporate borrower, EIP Global, is a Delaware corporation that was pleaded by the defendants in the complaint they drafted for the plaintiff. All they had to do, they are the ones who chose to make New York law applicable to the forbearance agreement. Had they simply made Delaware law applicable to the forbearance agreement, it would have been enforceable. Because under Delaware law, 6 Delaware Code Section 2306, which this court should take judicial notice of, a corporation, an LLC, and even guarantors of a corporation's loan cannot interpose usury as a defense to that corporate loan agreement. That's Delaware law. That was a simple way to deal with it. The problem was these defendants didn't know the law. And the motion to dismiss under 3211A7, this was a motion to dismiss. There would have to be a finding that the defendant's conduct and their chosen strategy was reasonable as a matter of law, and that there can't be here because they drafted a facially usurious, unenforceable, criminally usurious under New York law, agreement that forbade my client from collecting additional consideration that the borrowers, the corporate borrower and the corporate guarantor agreed to. My client wasn't responsible for knowing the law. My client wasn't responsible for knowing the distinctions between Delaware and New York law. It was the defendants. Again, we're on a motion to dismiss. What's shocking to me when I read the defendant's appellate brief is they try to take the position that the court in the underlying case, Justice Kern, you were on that decision, somehow ruled that the forbearance fee was enforceable and blames my client for not trying to enforce it with Justice Sherwood. That shows they still don't understand the law. This court, Justice Kern, you in particular, ruled that the forbearance agreement because of estoppel that we raised on appeal could give Mr. Salomon the basis to get some of the equitable relief in the forbearance agreement, the corporate disclosures, but not the forbearance fee, citing Seidel. And Seidel, as a matter of law, if they would have just read it, makes it clear. Although equitable estoppel protects some aspects of a tainted usurious loan, it doesn't give the plaintiff the ability to collect on the usurious interest. And that's why, Justice Kern, you modified Justice Sherwood's decision in the court below. But all of that being aside, we are on a motion to dismiss a 3211A7 granting by Justice
Sure, but
Hagler.
a lot of times, the legal malpractice cases get decided on a 3211, that commonly they do.
Understood.
Because the burden is so high in a legal malpractice case. So there's nothing inappropriate about deciding this one way or another in the context of a motion to dismiss. You have to show that there would be a viable claim and that there would be damages.
And here the problem with Justice Hagler's
Was your
decision.
main argument that the forbearance agreement would have been valid, the fee would have been valid under Delaware law, even though it would never been enforceable under New York law, and therefore it was malpractice to not apply is that the argument you're making?
That's certainly one aspect. There were lots of different ways to protect the client.
Because you haven't really articulated another way, is there another way that to have
Well,
protected the client? Because if the forbearance fee is not allowed, it's not allowed, and there's no damages from not getting it.
Again, that's a decision that they made to make this under New York law. The corporate borrower is a Delaware LLC. They should have made it Delaware law. That was one way to avoid it. The other way, the step-up interest, they stepped it up to 20%. They could have stepped it up to 16%, and my client would have been able to recover at least that much, even if there was no Delaware corporate borrower. So there were lots of ways. We haven't developed any of that in the
Still wouldn't have
record.
given them the forbearance fee.
I'm sorry?
Wasn't the forbearance fee over and above the interest?
This court, and Your Honor, decided that the forbearance fee constitutes additional interest, that plus the step-up interest, because the demand note had 10%, forbearance agreement stepped it up to 20%. So if you add the new 20% interest plus the $300,000 forbearance fee, this court determined as a matter of law it's criminally usurious under New York law. Under Delaware law, it wouldn't have been. And had they considered that and advised my client about that, they could have reworked the forbearance agreement, reworked it, made it 16% interest, figured out a way to deal with it. But at least they have to advise my client of his rights, and he would have been able to recover more. And they admit in their opposition that my client was damaged. He lost the value of that $300,000, and he lost the ability to get the step-up interest.
But he certainly gained it back in his interest and everything else. I mean,
No,
he wouldn't have had.
only under the demand note, the original 10% interest. Yeah, he was made whole under the demand note. But this case is about the forbearance
I
agreement.
understand.
He was not made whole
I
on that.
understand what your argument is. Thank you very much.
Thank you.
May it please the court, Peter Bigging, Goldberg, Segala for the respondents. I guess I'm taken aback by the allegations that are being made about Delaware law. I have a copy of the complaint that's part of the record. I don't see any allegations that there was a failure to act as a reasonably competent lawyer by failing to identify Delaware law and write it under Delaware law.
Well, but there are allegations in the complaint that an alternative strategy could have been used. And I think that that's sufficient at this stage, given that we have to read it.
I don't believe that that's alleged. I think they allege that it was simply a facially invalid agreement. The other point I want to make is...
They also argue that your client should have separately documented the agreement to compensate plaintiff for his lost opportunity to immediately repurchase the Apple stock. So there are other ways that they allege that, and I think that given our obligation to read the complaint favorably to the plaintiff, that that's sufficient.
Respectfully, I don't think you can make completely new allegations on appeal.
Well, could you describe to me what the reasonable strategy is that your client was following by drafting a facially usurious document and apparently never advising his client that it was a facially usurious document?
So my reading of the law is that as the
Could you describe to me what the reasonable strategy is that your client was following?
My understanding is that usury, that you can stop a defense of usury.
But he didn't argue estoppel to Justice Sherwood, so it appears that he wasn't even aware of that as a defense.
I believe usury was argued as...
No, estoppel was not argued to Justice Sherwood.
I believe that was argued.
There's no indication of that. It wasn't in the record at all. And certainly Justice Sherwood didn't address any argument by your client that he had a theory of estoppel.
I think at the end of the day, if you go back to the law as was pointed out, lawyers can make errors in judgment, lawyers can make errors during argument, but if they make a reasonable choice...
What's your response to his argument that if you had simply, not you, but the lawyer had simply used Delaware law under the agreement, it would have been enforceable, and that at least it's alleged that it was malpractice, assuming that we can consider that issue. I know you're arguing we shouldn't consider it, but if we do consider it, what's your response to it?
My response is, this is completely new to me. This is the first time I've heard this. In all the papers that have been filed, we made a motion for summary judgment. We made a motion to dismiss. We argued the motion. We argued the motion for over an hour before Justice Hagler.
Okay, what about 16%
first.
instead of 20% interest? What about the argument that 16% interest would have been sufficient?
Again, I don't know that. I don't know if what number would have been sufficient. I think a 20% was asserted, and I think I think that's been found to be sufficient. I believe that at the end of the day, if somebody has asserted asserted a defense of usury, they will be stopped from asserting that defense if they induced it.
But if your client was aware of the defense of estoppel, why wouldn't he have had the borrower execute a certificate of estoppel so that issue would have been put to bed?
That I guess in theory you could have done that, but again, I don't think there's reason. The standard is not doing it absolutely
Well, but
perfectly.
if he thought that usury was not going to be a problem because of the estoppel defense, the obvious solution would have been to have the borrower execute a certificate of estoppel. So why wouldn't that have been the reasonable strategy to follow if it hadn't occurred to him to proceed under Delaware law?
Again, it's a possible reasonable strategy, but I don't think that the standard is that if you don't use every possible strategy.
But what was your client's reasonable strategy? That's what I'm not understanding.
See, I guess where I'm confused, Your Honor, is that where I'm losing the thread is in the appellate division decision on this. It was found that an estoppel argument in response to the usury defense would provide a basis for pursuing the claim. And I don't understand.
That's not what your client, that's not the position the lawyer ever took. That's what the appellate court found, but that is not the basis that the lawyer used in drafting the forbearance agreement. Like, oh yes, this is going to be okay because the court will enforce an estoppel.
If the appellate court took that position, then the solution would have been, where I think this was lost, was that instead of going back to the Supreme Court and saying, hey, look, the appellate division has said, and Justice Hagler pointed it out in his decision, the appellate division has specifically said that there's a defense to, there's an estoppel argument to the usury defense, and they should have just gone back to the Supreme Court and said, we want to pursue that claim on that basis. And they didn't do so.
You don't claim that your client ever, that there's any evidence in the record that your client ever considered estoppel as a defense to the usury argument, correct?
Well, this is, again, we're just on the pleadings.
Is there any evidence is there anything that you would point to that suggests that your client had ever considered that?
Again, this is, I can only say that because this is on the pleadings, the only thing in the record is the pleadings. But I think that at the end of the day, what happened here was the appellate division found that sufficient facts had been alleged and put in the record to create an estoppel argument in response to the usury defense. And
No, thanks.
that's a reasonable tactic that was taken.
Thank you.
The very problem we have here is that counsel just still doesn't get it. The First Department, Justice Kern, you were on the panel. You only modified Justice Sherwood under Seidel. You did not say the forbearance fee was enforceable. You just said because estoppel is being raised for the first time on appeal and the special relationship was pleaded sufficiently, there are certain equitable aspects of the forbearance agreement that are enforceable. And
there was
citing
nothing
Seidel.
Am I correct that there was nothing in the forbearance agreement from which one could infer the special relationship between them?
No, that was all in the pleadings. But again, he's missing the point. The forbearance fee was determined by this court because they drafted this under New York law as unenforceable, citing Seidel. Seidel states, this is the Court of Appeals, 1992, 79 New York 2nd, 735, the one case, Justice Kern, your panel cited, quote, If there is an estoppel, the illegal transaction is not entirely purged of its taint, and balancing the competing interests of law and equity means the lender is permitted to recover only the amount advanced with interest rather than to enforce the usurious agreement for its face amount. And so all that meant was that, and that's why the panel said, it modified Justice Sherwood's decision to allow for the forbearance agreements provision for corporate disclosures to be enforced, but not the forbearance fee.
Where do you allege in the complaint, since this is a motion to dismiss, that if they had put in Delaware law, that would have been a way, and that they didn't do that, and that was the malpractice? Do you actually make that allegation in the complaint?
We make the broader allegation that they were the lawyers that drafted this loan document, the forbearance agreement, and they drafted it as an unenforceable, usurious forbearance agreement. There's going to be in discovery, I suspect,
So the answer is there is.
reasons for the
So
malpractice.
the answer is there isn't anything about Delaware law.
The complaint itself doesn't, but the complaint is broadly drafted to tag them for the malpractice of drafting a unenforceable, criminally usurious forbearance fee under their selected New York law. That's the complaint. I don't have to drill down every aspect.
Thank you,
of
counsel.
negligence. Thank you so much.
Thank you both. Bank of New York versus Bosboom.
Afternoon. May it please the court. My name is Jose Echeverria. I'm on behalf of the.
Speak up, please.
My name is Jose Echeverria. I'm appearing on behalf of the appellate.
Hey, let me ask you this. So you challenged the defendant's renewal motion as untimely, but isn't it timely as long as it's made before the entry of a final judgment? And isn't your main issue about FAPA, haven't we already, with two people on this panel, by the way, decided that FAPA is retroactive in the Genovese versus National Mortgage case?
Yes, Your Honor, and we're not arguing that the FAPA is not
You have to keep your voice up and speak into the mic, yes.
We're not arguing that the FAPA is not retroactive. We're arguing that it's not retroactive as it pertains to this case, since an order was already entered discussing the statute of limitations in 2021, and the judge.
There was no final judgment entered in this case.
There was no final judgment, but there was
Why
an
isn't it
order.
timely?
Because the order was final in itself. He wouldn't be able to bring it up. He would be able to appeal it at that moment. It was a summary judgment motion seeking to dismiss the case due to statute of limitations. The judge gave an analysis, applied the law at the time, and stated that the motion to dismiss is denied due to the present case being filed within the period of the statute of limitations. It wasn't only until 2022 when FAPA was passed, which was about 17 months after the order was entered, dismissing defendant's motion to dismiss due to the statute of limitations issue. And then it wasn't until 19 months after the FAPA was enacted that defendant filed the motion to renew.
You're saying that the judgment was entered?
Sorry, an order was entered. An order was entered dismissing defendant's statute of dismissal. Sorry, an order was entered dismissing defendant's motion to dismiss the case due to statute of limitations, and that was entered in May.
There was no judgment.
Sorry, order.
There was no final judgment.
There was no final judgment in that case.
So then you can file a motion as long as it's before the final judgment.
Our position is that you can file a motion to renew. Is that you can file a motion to renew within 30 days or within the period to appeal from the final judgment. In this instance, he was able to appeal the order when it was given, and he chose not to.
You have anything else?
I will keep it for rebuttal, Your Honor.
Thank you.
Please the court. My name is Mark Block, counsel for defendant respondents Dorleen Bosboon and Steve DiCrescenzo. The current matter, through no fault of the parties, renders exciting application of statute of limitations to accelerate mortgage and systemic abuse of the court system by mortgage holders. I'm going to cut out a lot of what I had set down and just address one or two points that seems to be of interest to the court. Unless you want me to go into.
No, you should, you should.
The lower court, okay, there's this argument that has just been put forth that somehow the Bank of New York had relied on Engel to their detriment. There's an absurdity to that, in that Engel came down after the filing of the complaint. This case started not under Engel, but under prior case law, which even in Engel, it was acknowledged that the case law was, the precedent was varied and non-reliable. So it's just not possible for the Bank of New York to have relied upon Engel to their detriment during for purposes of retroactivity. Plus, the lower court further rejected the argument that Bank of New York was relying on the holding of Engel, giving the swift reaction by the legislator and considering that the applicable holdings were of questionable first impression. Basically, there's just no basis, no way they could have relied on it to their detriment, which undermined the retroactivity of the application. I'd also like to address this issue about the timeliness of the motion. There's a lot of there seems to be a lot of, and not attacking the arguer here, but there seems to be a lot of a confusion between the time limits on a motion to renew and time on a motion to re-argue. This is a motion under 2221E, the CPR, sorry, 2221E, which does not impose a time limit on motions for relief to renew, unlike motions for relief to re-argue, which must be made before the expiration of the time in which to make an appeal. This was explained in Red Ivy Progressive. In an effort to protect the finality of judgments, courts have imposed a 30-day limit to file motions to renew on change of law following expiration of a time to effect appeal on the final judgment.
And there was no final judgment here.
There was no final judgment. And to the extent that there was a denial of a motion to dismiss, that is not a final judgment in any way, shape, or form. It's just that it's a statement that under the law at the time, there wasn't a basis for it, but it's not a final judgment, and therefore the 30-day doesn't even begin to apply. If there are no
And you do believe that FAPA is retro, based on our case law, correct?
Yes.
Thank you.
It's your case law and a plethora of other case laws, and the legislature's own comments.
Thank you.
Thank you very much.
In regards to the appellant relying on the detriment of Engels, that is accurate. The appellant followed Engels to the letter T to deaccelerate the loan by filing a motion to discontinue the 2011 action in 2013. A judge entered the order. All parties had notice of the discontinuance and canceling the les pendants. A judge entered that order in 2013, discontinuing the action, and that was based off of Engels requiring only an affirmative act to dismiss, to deaccelerate, which dismissal at that time, or discontinuance at that time, was an affirmative act from a bank to deaccelerate a loan. So at that time, and up until FAPA was executed in 2022, Engels was the law, was the ruling law, and required just an affirmative act, which filing a dismissal was enough. And then this present case was filed in 2018. It was already determined in 2020. 2020, defendant filed a motion to dismiss due to a statute of limitations issue. It was heard and determined in 2021 that the statute of limitations, that the present case was filed within the statute of limitations and denied defendant's order seeking to dismiss the case. Now, 19 months later, defendant comes back seeking to renew his summary judgment motion denying dismissing the case due to statute of limitations. Now with this new statute, FAPA. However, sorry.
Well, I was just going to say it's still before the final judgment, so he has every right to do so.
It's the right to do so, and however, not to bring up a motion. In that initial summary judgment motion, if it was filed after FAPA, that would be the time for him to utilize FAPA in his retroactive application to a loan that was dismissed in 2011.
It could be done any time before the entry of a final judgment.
Okay, Your Honor. We still hold that it does not retroactively change a judicial final order or determination.
Thank you. Thank you both. Bridgerton, 396 Broadway versus High Rise Engineering.
Good afternoon. Chris Georgioulas for the plaintiff appellant, Bridgeton.
I'm going to just ask you to raise your voice a bit.
I'm sorry, Your Honor.
And speak into the mic.
Yeah, the court, after trial, the court dismissed the case, finding that there were no damages and that there wasn't a breach. And I submit on both points the court was wrong. There was the defendant here is a bank engineer. It serves a purpose on construction projects.
This is High Rise you're talking about.
Correct, High Rise.
So High Rise stepped into the shoes of ARH, right?
Well, High Rise, yes, in a sense, in a construction project, a lender who's not
I'm sorry, no, High Rise, Bridgerton, the owner,
Bridgerton
stepped
is-
into the,
right.
to the shoes of ARH. And you are saying that High Rise breached the contract with ARH.
Your Honor,
Because-
what you're describing now is what the problem has been both at trial and in the strategy.
What's that problem?
The problem is there's just a misunderstanding of the roles. High Rise had a
Well, there's lots of testimony at trial about the roles that seems to
Right, well,
clear
I'm
up
gonna
any
explain.
misunderstanding.
Sure, High Rise has a specific role.
I didn't think that, it seemed to me that there was no issue about roles, that the trial court's conclusion was that High Rise gave the reports it was supposed to give at the time it was supposed to give them, and therefore didn't breach the contract.
But
I didn't see anything in your briefs that contradicted that. So I'm frankly, I don't understand what your argument is as to how High Rise violated the contract as between it and Raji, because it didn't have a contract with Bridgeton. Bridgeton was just the assignee.
Your Honor, High Rise had to look at the project documentation and had to provide accurate information. Those reports were filled with inaccurate information.
And how did you prove that at trial?
I provided the reports and the admissions of the defendant. And specifically, for example,
The court found that the reports were accurate. Why shouldn't we give deference to
Because
that? We generally give deference to it in a bench trial that it's correct.
The defendant admitted one of the services it was supposed to provide is verification of work before it recommends payment of a construction draw. That is one of the essential services. It's in the record. It's an admission.
I'm sorry. Where in High Rise's contract does it say that it has to approve those kinds of payments? Its obligation was to give reports, not to approve payments.
And within the report, it recommended payments and approved the draws. That's the whole point. Otherwise, why do we need Why do we need high-rise at all? It could have just said.
So high-rise, at least from the contract, says it's to perform certain review tasks and to generate specified reports for the lender. They communicated with the lender. In terms of the payment, it seems the architect was the one who was to certify the payment requisitions that were made by the construction manager.
The lender is a separate entity. It
Yes.
does not want to pay its money until High-Rise says, pay the money. That recommendation is critical. Here is
Where
this-
in the contract between High-Rise and Raji, or ARH, does it say that it's High-Rise's obligation to decide whether or not the payment should be made, as opposed to making reports?
It's the defendant, the principal owner, Celentano, actually tells us what his services are. Not everything is like every word is in the contract, but it's in the report itself. It says they approved and recommended payment, and that's a service that's integral to the whole relationship. Why are they there? If they're gonna rubber stamp the architect's certification, why is High-Rise there? There's no point of High-Rise being involved in the project. That's why they're there, to
So
protect
do you
the lender.
agree, do you agree that there's nothing in the contract that says that it's High-Rise's obligation to state, to approve of payments?
No, I don't. There is. In fact, the court, on page R8 of the record, the court sets out what it's supposed to do. R8, from the bottom of R8 to the top of R9, it discusses, it gives bullet points taken directly from the contract as to what it's supposed to do. And for example, analysis of construction hardcore budgets and contractor costs. I'll give you an example, prime example of one of the big problems. A GMP contract, guaranteed maximum price contract, is basically a contract that is financially transparent, meaning you take all the subcontracts, the trade subcontracts, you add them up, and they become basically the cost of the work, which is, there are other costs too, there are fees and stuff like that, but in general sense. So you need to have subcontract agreements that are executed. So the report that High-Rise generated and gave to the lender said all of the subcontracts were executed. None of the subcontracts were executed. That's a critical function of High-Rise, to look at the project documentation because it affects the security, the financial interest of the lender.
I'm looking at the record on page 8, and there's nothing that says that that's High-Rise's obligation.
Your Honor, analysis of construction hard cost reports, description of all construction risks could impact timely completion, cause cost overruns, impact construction quality. That's all part of that.
Counsel, there was a trial here, and the judge made an assessment based on credibility and the testimony that he heard. And at the end of that assessment, at the end of that assessment, made a determination that High-Rise was not responsible for those things that you are talking about. They were not responsible, but that the architect was responsible. If you have something different, then, because you've
But
gone
that's the
on, I've
problem,
given
Your
you your
Honor.
time.
That's the problem. It's the reliance on the architect's certification by even their experts said you'd never rely on the architect's certification.
Yes, but, you know,
That's what they did.
experts, then the court, you agreed to go forward with a bench trial, then the court made an assessment based on that expert, and I don't think that was the only expert. And based on Centeno's testimony.
So Celentano should not even have been
Celentano.
allowed to testify. He had no personal knowledge at all, at all. And
He
I
was
don't-
the owner of High-Rise.
Yes, but no knowledge and admitted.
Okay,
I
thank
took him on voir
Do you
dire.
have an expert with regard to the departure, the malpractice? Did you have any expert? Did you have any kind of evidence?
We had the admissions of High-Rise. We have Conor O'Byrne, who was a 20-year engineer, who was actually a fact witness and obviously expertise. We had Sanicola, another engineer from the defendant, and everybody said basically the same thing. What are the services that they're supposed to provide? And they didn't provide the services. They provided inaccurate information that resulted in...
Let's hear from your opposing counsel, and you'll have rebuttal time.
Please the court, Martin Schwartzberg on behalf of High Rise Engineering. The judge properly found in her decision that High Rise did not breach its contract. The contract specifically states what High Rise was going to do and what they were not responsible for. They were not responsible for the malfeasance of the architect, by the contractor. All High Rise was supposed to do with regard to the payment requisitions is review and comment on them, and that's what they did.
And did it have any obligation under its contract to approve payment requisitions?
Absolutely not. It said review and comment on, and that's exactly what the reports did. For example, the first report at trial, one of the big issues was $1.5 million in deposits that were paid pursuant to the first payment requisition. That first payment requisition was paid the day after High Rise was hired and before High Rise issued any reports. And even Bridgeton's principal acknowledged that High Rise could not be responsible for that. And the report said, the first construction progress report said, 46% of the requested amount is for deposits. It's at the lender's discretion as to whether or not they want to fund it or not. There's just, counsel was citing to page 8 of the record. He was citing to requirements of the plan and cost review. Under normal circumstances, the plan and cost review is provided to determine the feasibility of the project, as the contract says, issued before any lender is, and before any contractor starts digging.
So it normally would have been submitted before the contract with High Rise was even signed?
Yes, yes. Normally, the plan and cost review reviews and analyzes all the documents that the owner gives to High Rise. High Rise tells the lender, yes, this project is doable for the budget they're saying, or no, it's not. These are the issues we have with the plans, et cetera, et cetera. That's the plan and cost review. It's normally done before a lender agrees to fund a project. That isn't what happened here. High Rise was brought in, the contractor entered into a contract in February of 2015. High Rise contract was signed July 30th, 2015. The day after High Rise was hired, they wired payments to the contractor before High Rise had an opportunity to do anything with regard to this project. The contract lays out specifically what High Rise was required to do, and the court below properly found that High Rise did it. Brett Sanicola, the engineer who prepared every construction progress report, testified as to the 8 items that are required in the contract, and that each of these 8 items were provided in each of the construction progress reports. So the court properly found that High Rise complied with its contractual obligations as stated in the contract, and not certifying payments, which was not their obligation. That was specifically the architect's obligation under the architect's contract, and the architect is the one that signed the certifications on each payment record.
And that's DXA.
I'm sorry?
That was DXA.
DXA was the architect who they have not sued, although a notice of claim letter was sent to them back on December 1st of 2016.
Also, in the contract, I'm sorry to interrupt you, it's in my
Please,
nature
go
as a
ahead,
judge.
please.
The contract was between High Rise and ARHA.
Yes,
And High Rise was supposed to do 2 things, the PCRs and the CPRs.
correct.
Was any witness proffered from ARH at the trial?
No, that's the whole thing. In a normal circumstance, High Rise is hired by the bank. Here, and there's a wall between the bank and the owner because their interests can conflict at a certain point in time. Here, the representative of the lender was also the principal of Bridgeton, who had testified at trial that he was an agent of the bank and he was a fiduciary for the bank. Well, guess what? High Rise relied upon the documents that the principal of Bridgeton sent to them. Why wouldn't they have a right to rely upon the documents that the owner sent that's also the representative of the bank? And the other issue is with regard to the assignment. The damages that plaintiff proffered at the time of trial were damages incurred by the owner, Bridgeton, not by the bank. The loan agreement was never introduced at the trial, so we didn't even know what was required under the loan agreement. There were no wire transfers from the bank to indicate any payment was made to the bank. The only testimony about payment being made by the lender was vague testimony by Bridge and Sprint, and oh yeah, after we paid them, they wired us the money. No evidence whatsoever as to any amounts that the bank wired them. And as a matter of fact, if this project cost Bridgeton more than what was originally, then the bank probably made money on it because they would charge interest on the extra money they had to pay to finish the project. We don't know either way because the damages were never proven, no damages were proven with regard to the lender. The only damages proven at the time of trial were the damages incurred by Bridgeton.
Thank you. Counsel?
To answer Your Honor's question about approval, each payment was approved by High Rise. It's in each construction progress report. It says approval, and there's also a column that says recommending for payment. So if they didn't have that obligation, why would they put that in their report? The lenders, the bank engineer, that's one of the key functions of the bank, as stated by Mr. Celentano. You verify that the work is there, and then you approve. Whether the architect certifies or not is irrelevant with regard to the relationship between the bank engineer and the lender. They have to do an independent assessment. Did they do the work? Here, CBRE, a national firm, testified as to the work in place of less than $1.5 million, and they approved $3.8 million worth of work.
But CBRE was only one expert. There was a.
I'm sorry?
CBRE was only one expert. There was an opposing expert, and the judge had the opportunity to make the determination at the end.
Nobody testified about work in place other than CBRE. No one else. There's now one.
None of the other two experts.
Nobody testified about work in place other than Richard Rosenthal of CBRE, who spent a day there with the plans and went through everything, and he talked about the methodology used, which was confirmed as the appropriate methodology by their expert, Joseph Walworth. He said, yeah, that's how you prove overbilling. You look at what's in place and then what was paid, and the difference is the overbilled amount. And here, that's exactly what happened. And it's all as a result, because if they don't recommend and approve the payment, those payments would never have been made, other than the first one. But the client already recovered what was the first one. They got $1.5 million in work actually performed, and they got $600,000 in a settlement with the contractor. So that first payment had nothing to do with the damages in this case. Thank you.
Thank you both. JS versus the City of New York.
May it please the court, my name is David Rutherford. I represent defendants, appellants, Homes for the Homeless, and Homes for the Homeless summer camps.
Counsel, what causes of action did the plaintiff allege in the complaint against you, your client, that makes your client liable for activities that took place before you were incorporated?
None. So they only alleged a negligence cause of action. They never alleged what I think they now say, which is successor corporate liability.
When did your client incorporate?
1986 for Homes for the Homeless, 1990 for Homes for the Homeless summer camp.
And when did the allegations here take place?
1967 and 1968.
What about the new theory of successor liability?
Well, first of all, it was never pled. And since it was never pled, it cannot be asserted in opposition to a summary judgment motion. And interestingly, in the original complaint, the operator of the camp, which at the time was Boys Athletic League, then changed their name to Pathways for Youth. They weren't in the case originally. The plaintiff amended their complaint after we filed our summary judgment motion, and after they knew that we were saying we weren't in existence then, and they brought in Pathways. Pathways is, in fact, in the complaint. The operator of the camp at the time is actually a defendant. They never alleged successor corporate liability. And there's been no purchase of assets. There's been no transaction between my clients and Pathways. Without that, there can't be any successor liability.
Your argument is that we shouldn't even address the issue of successor liability, that it was brought up too late, and it's not appropriate for us at this point in litigation to address the merits of it.
Absolutely. That's our primary argument. And even if they tried to do it now, there's no evidence that could possibly support such an allegation because there's no transaction. So it's really two grounds, but the primary one is it was never alleged, and if it's never alleged, they can't pursue it.
Thank you.
Jason Rubin from Herman Law, representing plaintiff respondent. The fact that it wasn't alleged was never brought up in the lower court. This is not an issue that's preserved for appeal. They never made the
What are you
argument.
talking about, successor liability?
Correct. They never argued in the court.
It was only a theory that was raised, I believe, in opposition to the motion to dismiss.
Correct.
So
It
you
wasn't-
can't raise a new theory in opposition to a motion to
But
dismiss.
in the posture of this motion, which was under 3211A1, they have to, the documents that they submit have to utterly refute plaintiff's claims. And they never,
But plaintiff's claim, in order to be successful, as to this defendant, has to allege successor liability, since this defendant didn't exist until more than 20 years after the incidents at issue. So if you didn't allege successor liability, how can you claim, what is your claim?
we argued successor liability in the motion below. So the court.
You didn't argue it, and you didn't raise it in your complaint.
It wasn't in the complaint, I'll concede that, but it was argued in the court below. And the argument was never made by defense that that needed to be pled in that complaint. We could have made a motion to amend
But
the
you
complaint.
can correct a pleading in opposition, but you can't raise a new theory in opposition to a motion.
Well,
it was a totally new theory. It had never been pled or stated
It wasn't
before.
pled, I will concede that. But it was argued that Homes for the Homeless could have successor liability for the prior operator of the camp. And there is evidence of potential successor liability from the website that the Homes for the Homeless has for this camp, Camp Lanoa.
And does it indicate that, I didn't see anything that suggests that it indicates that
Well, it was the same.
that they purchased the assets of the prior.
No, it's not. It was the same director of the camp. They used the same name. It was in the same location. And those are factors that can be considered to determine whether or not there was a de facto merger between the predecessor corporation and the successor corporation.
Well, I mean, there are 4 factors. I haven't heard you articulate any one of them that would suggest that they were even if this had been
There is
pled properly.
continuity of management, personnel, physical location.
So there's the predecessor. They didn't assume or impliedly assume the predecessor tort liability.
Well, we don't know that yet. We don't really know that because of the posture of the case. This was a pre-answer motion to dismiss. This wasn't a summary judgment motion. The court treated it as a pre-answer motion to dismiss, didn't convert it to a summary judgment motion. So given the posture of the case, when the court decided it, it made the right decision.
Do you have anything else?
No, I don't, Your Honor.
Okay, thank you.
Just 2 quick points. You got to look at what's pled. There's only negligence pled. Negligence is duty, breach, proximate cause, damages. They don't meet the first element, duty, because we didn't exist at the time that this took place. And as to the issue of why didn't we raise it in our original moving papers, why would we? The complaint only said negligence, so we argued negligence. Then they bring up this possible successor corporate liability argument, which was totally improper. But let me just say one thing. The 4 factors, the Schumacher test, you have to have a transaction first, a purchase of assets or something that ties the 2 companies together. If you don't have that, you can't go into any of those factors. And even if you went into the factors, none of them are present anyway. So regardless, there's no case here against my clients.
Thank you. Thank you both. People versus Luis Gonzalez.
Good afternoon, and may it please the court. Elizabeth Lagerfeld from the Center for Appellate Litigation for appellant Mr. Luis Gonzalez.
Counsel, the people argue that the defendant abandoned the bag and alternatively that there was an emergency exception for the bag search. Were either of those issues addressed by the court or the people below?
They were not, Your Honor. Neither of those issues were addressed.
What was the ground to deny suppression below?
The grounds were that Mr. Gonzalez's stepmother had given her consent to search her apartment, which is where the backpack was. But
so I think the court said, I believe a consent to search an apartment is consent to search any room and anything within the apartment.
That's correct, Your Honor.
Is that accurate?
No, Your Honor, not in this case, because everyone knew, the police knew, and it was completely uncontroversial that this was Mr. Gonzalez's bag, not his stepmother's. His stepmother wasn't saying, this is my bag, or, you know, I have dominion over this bag. She knew it was his. Everyone knew it was his. And the Court of Appeal, yes, Your Honor?
I was just going to ask, if she was concerned that there was a gun in that bag, could the police officer have just taken the bag, gone back to the precinct, and then gotten a warrant to open it?
Certainly.
I think she didn't only think that there was a gun in the bag. The police officer felt the gun in the bag
was
without
after,
opening it.
Right, Your Honor. So that was after they had already done the search and they had already begun to frisk the bag. But the important thing to remember here is that with respect to any exigency argument, first of all, it's completely unpreserved. This was not addressed by the court below. Second of all, there's actually no exigency here. There's no time issue here because this was a completely secure scene. This was an apartment that had already been cleared. The safety sweep had been done. Mr. Gonzalez had been arrested over an hour prior. It was a closed and empty apartment, and actually one of the officers testified that, yes, if the bag is there unattended, if it's not being moved, there is no safety concern. He testified to that. Their concern was if we move it, if we release the scene, that does not explain why they can't keep the scene secured and get a warrant.
You're talking about leaving the bag in the apartment.
Yes, Your Honor.
Is that that's what you're speaking to?
Yes.
Leaving the bag in the apartment.
And
was there any violation in there after being given the right to search this by the person who owned the apartment? Was there any problem with them removing the closed bag from the apartment, which is what I think they did. They removed the closed bag from the apartment.
So according to the hearing officer's testimony, they actually opened the bag inside the apartment.
Inside the apartment.
So what I think the most important violation here is the opening of the bag. This is a closed container. They knew it was his. They went in there because they wanted this bag and they wanted his bag. And there was absolutely nothing stopping them from simply keeping the scene secured.
Or leaving the apartment with the bag and keeping the bag closed.
Either of those things, and getting a warrant. And that's what the warrant requirement is about. That's what the Fourth Amendment is about. And just as to the argument that the people are making, that the police knew that Mr. Gonzalez was trespassing,
that he abandoned the bag.
He abandoned his bag. That's really not what happened here. Police arrested him. He didn't abandon
That's not what the court held anyway.
It's not.
That wasn't the basis for the court. The court held
it was not
to the contrary.
Right. The court held it was based on her consent, right? Not on this abandonment issue.
And did they even argue that issue before the suppression court?
They did not, Your Honor. They did not. They all they said was, his stepmother's consent covers this bag because it covers everything in the apartment. But the Court of Appeals has said that's not true when the bag belongs to someone else and there's no ambiguity there. There's one thing, there's other cases where maybe there's some ambiguity.
I couldn't really find any cases on point. The main case, people Gonzalez, clearly they were a guest, but I guess the court didn't decide on that basis. There were no cases where the person was not a guest but left a bag behind.
Right. Well, the situation in this case, based on what the police knew at the time, is that there's a family dispute here. We've got stepmom and a son about whether he had a right to be there. One
I
person.
think there was maybe a question about whether he even lived there.
Right, and that was litigated, actually. That was what the whole trial was about. So from the perspective of the police opening this bag, for the people to come back and say this was already a done deal, that they knew, I mean, he was never even charged with trespassing, and actually the court rejected trespassing as a basis for his arrest because that just wasn't on the record at that time. Thank you.
Good afternoon, Your Honors, and may it please the court, Andrew Chung for the people. I'd like to just begin by addressing some of my adversaries' arguments. There seems to be some confusion here over whether or not we're arguing that the defendant here abandoned his bag. The primary argument that
If there's any confusion, that wasn't raised below, was it?
the abandonment wasn't explicitly mentioned below, but the particular
Why is
argument.
there confusion about it if it wasn't raised?
Oh no, the confusion is to
What is your argument?
Thank you, Your Honor. Our argument is simply that the defendant lacked a reasonable expectation of privacy in his bag because he left the bag behind when he was trespassing. It's not
Well,
particularly.
it was no charge of trespass, and this is where he may have even lived. The woman who said, "I want you to get that bag out of here," did not say that he didn't live there. She said, "I've been trying to get him out." She did not say he didn't live there. Besides, even if he didn't live there, but he was a guest, he certainly was allowed into the apartment. He didn't break into the apartment. He was in the apartment. This was not uncommon. And he was fighting with the other family members in the apartment. Because of his belligerent attitude, he was taken out in handcuffs for whatever the charge was. Then everyone said, he always has a bag and he has a gun in it. They couldn't get a search warrant, so they asked for permission and they were able to search the apartment. In the apartment, they found a closed bag. On what basis, under those circumstances, when the concern over someone who maybe could have used the gun or would have used the gun or was no longer the case because this defendant was long gone. So what was the basis upon which the officer opened the bag at that point?
Yes, Your Honor. The basis upon which the officer opened the bag was the Mrs. Gonzalez's consent to search the apartment. Now,
Consent to search the apartment did not give consent to search a closed drawer
Well, Your
or
Honor,
container or bag or
Well, Your
what
Honor,
case do you have that stands for that proposition?
yes, Your Honor. Well, as we cited in our brief, United States versus Sawyer is a Seventh Circuit case. It's not obviously, it's not directly it's not directly.
You have no New York State case.
We weren't
regard
able
to
to
search
find
and
a direct.
seizure.
We weren't able to find a directly on point New York State case.
And what you would have found are cases that say if a guest is in a house, you don't have the right to open the guest's.
Yes, Your Honor, but this individual was not a guest. He had been kicked out.
We don't have any information that he was not a guest because that is not what the owner of the apartment said. There is nothing that says this person was not permitted in the apartment.
Well, Your Honor, as we mentioned in our brief, there's evidence that came out below that they had asked this defendant to leave and that the mother of the.
Counsel, what about the problem which we talked about already, that that was not the basis of the court's finding? Even if you're correct, we cannot affirm on a basis that the court did not decide on. The court never made a finding of any type that this defendant was trespassing. So how can we rely on that in reaching our decision?
Yes, Your Honor, that's
as opposed to being a guest.
Yes, Your Honor, that's an excellent question. Well, the court below, when they made their decision, explicitly stated and cited that the detective here was concerned about the gun and the gun being in the apartment.
Right, but the court, where did the court make a finding that this defendant was not a guest or was uninvited or did not have some right to be here? Did the court ever make that finding that could be addressed at this point?
Well, Your Honor, the court explicitly stated that probable cause to arrest the defendant was found based on, among other things, the 911 call and conversations with the family members outside of the apartment.
That doesn't have anything to do with the fact as to whether or not he was a guest or not allowed to be in the apartment. He could have been allowed to be in the apartment, but then he started behaving in such a way that they needed him out because he was out of control. But that doesn't address the issue, and I don't think the court did ever make a finding that that he didn't have a right to be in the apartment in the first instance.
Well, Your Honor, respectfully, the evidence that came out at the suppression hearing below was that the stepmother had asked the defendant not to be in the apartment. This entire incident began because the defendant was inside of the apartment without her permission and against her express wishes.
Where's the court ruling about that, which is what we have to look at?
Yes, Your
Where
Honor.
did the court make a ruling about that?
The court didn't explicitly state that the defendant was trespassing in her decision, but again, the court doesn't need to explicitly state it for the appellate courts to be able to consider this issue.
The court just can't make up that somebody's trespassing. Somebody in the apartment has to allege facts on which the court can base such a finding. That's not there. It's nowhere on the record here.
Can you just tell me how this is different from the Court of Appeals case, People versus William Gonzalez?
I don't have that case directly in front of me, Your Honor, so I wouldn't be able to.
Okay, so the Court of Appeals said that you couldn't open a closed container.
Right.
And that would be a violation.
Right, Your Honor,
it
but
should
that
be suppressed.
Right, Your Honor, but that only applies when an individual has a reasonable expectation of privacy over the closed container. Here, the defendant lacks standing to even contest the search because he didn't have a reasonable expectation of privacy.
How do we know that?
But Your Honor, Detective Morrow and Detective Farrell both testified at the suppression hearing that they had interviewed members of the defendant's family, and the defendant's family members had explicitly stated that the defendant did not have permission to be inside the apartment. And so that, I think, is where the crux of this all lies down, is that the evidence that came down at the suppression hearing was that the defendant did not have permission to be in the apartment, and the defendant himself presented no evidence.
How did he get into the apartment?
I'm sorry, Your Honor.
He was in the apartment.
Yes, Your Honor.
Did he have a key?
That information didn't come out at the
Did
suppression hearing.
someone let him into the apartment?
Again, that information didn't
Well,
come out
the
at the
door was not broken. I mean, there was no question. He was in the apartment, not in the hallway, not in the threshold. He was in that apartment. He was clearly invited. He didn't break down a door. There's nobody alleged that he pushed himself in. And it was after he was in there that he started carrying on that they didn't want him in the apartment anymore. But he's certainly invited there.
Well, Your Honor,
or allowed or permitted in there. There's no evidence on this record that that was not the case.
Your Honor,
and there was no finding of any.
Well, Your Honor, there's also no evidence that this defendant was invited into the apartment at the suppression hearing. The information that came out at the suppression hearing based on the testimonies of the two detectives was that once Mrs. Gonzalez found out that the defendant was inside her apartment while she was at a doctor's appointment, she had called her cousin who lived in the building to get him out.
You're claiming that he had no reasonable expectation of privacy.
Yes, Your Honor.
And that burden is on you to show that. And how have you shown that?
Well, Your Honor, it's upon the defendant below to argue and to prove that he has standing, to prove that he has a reasonable expectation of privacy over his closed container. Here, there's no question that the legal owner of the apartment, in this case, Mrs. Gonzalez, had a reasonable expectation or could consent to a search of her own apartment to remove a dangerous object located
She
therein.
did. That much is true. That much is true. We don't disagree there. The problem is opening the bag. Thank you.
Thank you, Your Honors.
Okay, Your Honors. I just wanted to. I think we've covered most of what I wanted to cover, but I'll just go over a couple of fact points. Right? I think.
Do we know how he got into the apartment?
So
we know why
we
he was
don't
there?
have like a testimony about when he actually entered, but we do know his brother Demetrius testified. I unfortunately don't have the site with me, but he testified that he saw this bag in the apartment when the police came and asked everyone to leave the apartment. So that indicates to me they were all in there together in the apartment.
Who was in there? Because it wasn't anyone who was in the apartment who called for the police.
That's correct.
The mother-in-law, somebody called for the
this was a
stepmother rather called for the police. Who was in the apartment when the police came?
Well, at least his brother Demetrius. I don't know who else was there. It only comes up in this kind of reference where he says, I saw this bag when the police came and asked everyone to leave the apartment. So I'm not sure who else was in there. But the reason...
Is there any evidence that he broke into the apartment?
No. No
Was there any
whatsoever.
evidence that he, anything other than either he had a key or somebody let him in?
No, there's no evidence of that and there's no allegation of that. This was his, and there's no controversy that this was his family apartment. This is a place, it ended up being a big disputed trial. Was this still his home? But it was a place he had lived before. It was a place where his family lived. It was a place where he had been. So the police were facing this family dispute about whether he's allowed to be there. This is not a case, the Seventh Circuit case that the people are citing, People v. Sawyer, besides being Seventh Circuit case, that's about a burglary investigation. That's about where someone said, there's these strangers in my property. It has nothing to do with this kind of situation that we're dealing with here.
Thank you. Thank you. Thank you both. South 32 Chile versus Sumitomo Metal.
May it please the court, Tom White from Sullivan and Cromwell for the appellants.
Counsel, I'm going to start in a smaller subsection of taxes, because that's one of my primary questions for you, and that has to do with the 2012 and 2013 taxes. You make an argument in relation to the 2021 taxes and all the taxes that the relevant time frame to look at is when the tax returns are filed to determine when the interest is realized. If we do that and we accept that argument, which gives you a lot of the years, then why wouldn't we also apply that position to 2012 and 2013? And in that case, the income tax returns for those years recognized it. So why shouldn't there be a carve-out, assuming you win on the other years, why shouldn't there be a carve-out at a minimum for the 2012 and 2013 years?
Thank you, Justice Kern. That, of course, was not briefed below, and our frontline position is that the argument was forfeited. But getting to the substance, getting to the substance of your point, what happened with those tax years is that the interest had been recognized as taxable income, but defendants never got the money and concluded they weren't going to get the money. So in an amended return, they said that they were de-recognizing that income as taxable.
But your whole argument as to all the other years why it shouldn't be recognized in 2021, that's the whole linchpin of your argument, that you look at how the tax returns are filed, and that is a determinative date. And if you win on that argument, then I don't see how you can win on 2012 and 2013.
Again, if you're concerned about that, again, this only applies to one of two defendants and only 3 of the tax years.
That's 2015 for the other defendant.
So there was a 2014 return, which was amended. No, this is only one defendant. Sumitomo Corporation doesn't have this issue at all.
Well, didn't the same thing happen to them in 2015?
No, there's a 2012 and 2013 tax returns. Again, both just one of the two defendants, Sumitomo Metals Mining. The interest was originally recognized as taxable. That was true in a 2014 tax return as well. The 2014 tax return was basically immediately amended
within the year. That was done in the same year. So you have a better argument for the 2014 because when it was filed at the end of the year, it had already been amended in the same year. But I'm a little confused because I thought the same thing happened with defendant SGF in 2015.
No, this issue that Your Honor is referring to only applies to one of the two defendants, and it only applies in this conversation to the 2012 and 2013
I'm confused because when I read the briefs, I'm pretty sure they were also talking about 2015 and SGF. Is that?
Well, I'll take another
look.
look.
I can ask them.
Sure, I'll take another look when I sit down, but
you take a look at that when you sit down, because
Sure,
that's the way the briefs laid it out.
Sure, and again, so we'll look at that, but this issue is a narrow one. It relates to, as I said.
Let me ask you the bigger question then.
Sure.
So one of the biggest arguments that they're now pursuing, I don't think they're pushing as hard on that. It's they're still making the argument that it's recognized the year it's impaired, but assuming their new argument, which is that it occurs on the balance sheet date, why should we not accept that argument, or at least let the case go forward for a determination to be made at a later date, whether it's the balance sheet date versus the date that the tax returns are filed?
Because that issue is answered by the plain language of the contract. The word recognition answers that question. Now, income may have been accrued or realized during a calendar year, but it is not recognized until, and certainly not recognized as taxable income until the taxpayer's judgment is reflected on the tax return. That's just
What's the basis for that argument, other than, because the language doesn't really completely address it in the agreement. What's the basis for that position?
We give on pages 31 to 33 of our brief the dictionary definitions from tax treatises, from Black's Law Dictionary. That's what recognized
You're
means.
saying under New York law, which is what controls here, that's when income is.
Correct. That's the plain language of the term recognition. And again, certainly defendants didn't recognize that impaired interest as taxable. They didn't pay tax on it. They didn't get the money.
Well, let me
They
ask
didn't
something.
think they would.
You don't really address this, and maybe it's beyond what needs to be briefed, but is anything in stone at the time of the balance sheet, or could they then change it when they do the tax return later in the year?
So the way it works under the Dutch system and the US system is you look at the information that was available as of December 31, in this case 2021. But again, the question, the parties here agreed not to key the allocation of liability on the as of date, the as of December 31st date. The parties here chose to allocate liability based on whether the accrued interest had not yet been recognized as
And
taxable.
you're saying that tax
income.
filing is the date that it's recognized?
Correct.
So now, does that also then apply to the argument as to the 2021 year, that it wasn't actually recognized? I mean, I know there's a dispute going on between whether it's the closing or what, but accepting your argument, it shouldn't really be recognized till the tax returns are filed, which didn't happen until after the closing.
That's exactly right. So for the 2021 tax year, that interest accrued in 2021, but it wasn't recognized until June of 2022.
So if we accept your argument, you win on everything except maybe the 2012 and 2013. You're going to get back to me in the 2015.
I'm going to get back to you on that, Your Honor. But yes, that's correct. You just need to look at the definition of recognition, the definition of recognition as taxable income in order to rule in our favor. I completely agree with you, Justice.
You didn't recognize, you never got, we're deciding, if we decide on a motion to dismiss, it has to be based on the language of the agreement, but you never got the benefit of any of that money in 2014 or 15 or 16.
Correct. This is all, the dispute is about interest income that will go to South 32.
You're getting it all, so that you're arguing they should pay the taxes on it.
Of course, I mean, this is common sense. This is commercial reasonableness that New York courts apply all the time. Defendants did not agree to pay the tax on interest income that South 32 will be receiving.
Well, that's their argument, that it was a benefit, but we'll hear.
That is
Just let me, wait a minute, just let me ask you this, just with regard to that section that you both are relying on.
What section, Your Honor?
I'm sorry, 6.11E, 3 little I, where they are saying that, you know, you use this, the term tax impaired with regard to the interest.
Yes, Your
They're
Honor.
saying that, well, in that section, it was used impaired with regard to the principal. So they're saying, how could then the second part of that, which you're relying on, how could that indicate the impairment?
Yes, the answer, Your Honor, is that these items, which are both discussed in the same subclause, which is an indication that they're dealing with similar concepts, that second part relating to interest, and I'm reading from the language on page R282, the recognition of any accrued interest not yet recognized as taxable income on the shareholder loans. That is broader than principal impairment reversals because it can cover interest impairment reversals, but also, and this is important, the 2021 scenario. The 2021 interest had never been impaired, but it was recognized by South 32 when they, for the first time, when they filed their tax return in June of 2022. I'm happy to answer any other questions the court may have, but I've reserved some time for rebuttal.
On rebuttal, answer the 2015 question.
My colleague and I are going to look at that right away, Your Honor.
May it please the court, Aaron Marks, Kirkland Ellis for the respondent.
Let me ask you that question.
Yeah.
Because I remember that being argued in the briefs that
Page
defendant
508.
SGF did not take impairment for the interest it should have received from Sierra Gordon in 2015.
Yes, Your Honor, and that's correct. Page 508 of the record reflects that SGF did not impair interest with respect to 2015. We don't know, the issue with SGF, and which is a fact issue, they did impairments very differently than the other company, SMM. They impaired a lot of principal early, did not impair a lot of interest. We don't really know until discovery what the damages are with respect to SGF.
Okay, so let me ask you a question. For you to be successful on this motion, we have to reject their argument that income is recognized when the tax return is filed. What is incorrect about that argument? Because up until the time you file the tax return, there's nothing in stone yet about why isn't it recognized when the tax return is filed?
Okay, first, Your Honor, this is a motion to dismiss.
Right, but we have the right, I mean, that was one of the arguments. We clearly have the right on a motion to dismiss.
Correct.
If an agreement is unambiguous and we can determine it without looking at its extrinsic evidence, there's no reason for us not to address it on a motion.
100%. When recognition occurs, Your Honor, as to taxable income, the reason why our expert and we believe both U.S. and Dutch tax law provides that recognition occurs at the end of the taxable year that the interest had accrued in. December 31st, as it were the balance
You're
sheet.
saying if they were entitled to the interest in 2017 and they impaired it, it should still be deemed to have been realized in 2017. Still sticking with that argument.
Yeah, well, it's an accrual-based system, and it's two separate acts that happen.
But how can it be, I understand that's your argument, and there's a lot of complicated names you put in there, but just a common sense approach. How could income be realized? They didn't realize the income. They didn't get the income. Your client is getting all that, the benefit of all that interest. They never got the benefit of it, so why would that, how could they have realized it if they never got the benefit of it?
Your Honor, this was the benefit of the bargain, meaning that...
But I'm just looking at the language, because the only way they can win, and the only function that we have on a motion to dismiss, is to look at the actual language of the agreement.
Yes.
So that being the language about recognition...
Yes.
How does it support that it's anything but when they file the tax return, recognizing that interest?
Understand. I'm going to get a little technical. Accrual-based system, right? Interest is supposed to be paid on a loan, okay? On an accrual-based system versus a cash-based system, regardless of whether it's paid or not, it accrues. And it, on
That's
the date.
the Dutch system.
And it's
Isn't
the
it?
Dutch system. It's also New York and the U.S. if it's an accrual-based versus a cash-based system.
We don't have impairment in New York, I mean, in the United States. That's not a concept.
We do have this, and in an accrual-based system, this is how it works. That interest is included within taxable income, and what we had here, right? On this motion to dismiss, there were a lot of tax returns that were provided, okay? And they initially provided a tax return with their Dutch expert right at the beginning, the amended 2014 tax return, which, by the way, was never provided to South 32.
But it was amended within the very 2014 year.
That's fine, Your Honor. But their point was, look at this tax return.
Let me ask, you're saying, and this is the part that I don't really understand, you're saying they recognized it in earlier years, even though they never got any taxable benefit, and you clearly got the taxable benefit of that interest, that they should still be the ones who recognized it earlier.
Both sides agree that recognition is basically the recording of income, interest, as taxable on a return. That's recognition. Realization is an economic benefit that is something different. Okay, recognition is recording. And what happened here, right, is that these Dutch companies from 2012 to 2020.
You just said recognition is the recording, but the tax return is the recording, and that didn't happen until 2022.
No, Your Honor, every year, and every year, they.
How could it have been recognized every year if it was clearly recognized, according to even your definition, in 2022, when your client filed the 22 tax returns, it recognized all the interest for all those years.
Correct.
So how could it be recognized twice?
It's not recognized twice, Your Honor. It's recognized each year that there was interest income accrued. Each year a tax return was filed, and there was a column, right? And it had interest. Okay. Subsequent, also, if there was an impairment, there was a.
You're saying the impairment's a separate thing.
It's a separate act.
That's your argument.
It is a separate act, and that is the way it is commonly understood. That's why you have things happening in different years. And Your Honor asked, you had this interest that was reversed in 2021 that gets the tax return gets filed in 2022. The tax return could get filed in 2023 or 2024. The tax filing is a random date. The way that
it's not a random date because you did the tax return. They didn't do the tax return. It's still with them. They went to done it because they weren't recognizing it.
Well, Your Honor, they failed to do it. It was their obligation to do it, but they didn't even provide the returns. That's a different issue.
Because they didn't get the benefit.
But Your Honor, the issue is that the filing date is a random date because you can get extensions. You have various reasons for not filing. When someone talks about what things, about what occurred in the 2021 tax year, okay, you're talking, and when you're doing your 2021 taxes, all right, you're only considering things that happened, income that came in, interest that came in, things that got reversed within 2021, and it stops on December 31st. So recognition, yes, I could have filed the tax return in April of 2022. I could have filed it in December of 2023. That is meaningless under the tax law as to when it is that something is recognized. Unless you have other questions. Thank you.
Your Honor, I'm going to address this 2015 issue. Again, I don't see on page 508 their expert saying that this interest was recognized as taxable income. What you see in paragraph 2.1.2 of his report is that he couldn't even bring himself to offer the opinion that any of the interest at dispute was recognized as taxable. He literally put the word taxable in parentheses because he couldn't.
Somewhere in the record, I definitely read, forget about what the expert says, what the opinions are, because it's really for the court to ultimately interpret what the law is. The only thing that's relevant for the purposes of our determination is, was that income impaired in 2015? I don't think there's a factual dispute about that, which is a different issue than what the legal impact is.
What we know is that it was not pleaded, Your Honor. So
no, but that's your argument as to everything is 2012, 2013, 2000.
Well, two different points. There's a forfeiture.
Is there a any factual dispute in this case that it was impaired in 2015 for that company?
For the Sumitomo Corporation, no. I represent, this is my understanding, that the issue relates only to one of the two defendants. And
well, they're clearly making an allegation that as to SGF, that it did not take any impairment for 2015. Are you saying that's incorrect?
that is incorrect, is my understanding. And again, I think, so let me make two points.
I think that's at the record at 508, that no impairment was taken.
Right, but he does, I see that language relating to SGF, but he does not say that this income was recognized as taxable.
Again, that goes to the legal analysis. I'm just asking you about the fact, because we'll decide whether or not the contracts can be interpreted as a matter of law. The only question that I was asking you is if it's in the same legal position as to 2012 and 2013 for SMH as it is for SGF in 2015.
My understanding, again, this is a representation, is that that issue where the tax was originally paid only relates to the SMM defendant. With respect to the
Only
SGF,
relates to, I'm sorry, the SMM, you said.
I'm sorry, the SMM amendment, not the SC amendment. So I'd like to just make a couple of more points since it's been the focus of
That's
the
up to her since the time.
with the court's permission.
Sure.
The first is that if this were to, if we interpret it that way, it does not form part of the disputed taxes that are at issue in this case. I mean, paragraph 1 of their complaint says that all of the taxes are either 2021 or they were impaired. And the correct reading of the language is that, and we argued this in our brief, and I think it's quite right, Your Honor, that when you say not yet recognized, you're talking about a moment in time. The example we give is if you ask your child, are you ready for school yet? You're not asking whether at some point in ancient history, 5-6 years before this contract was signed, he was ready for school yet. It is a forward-looking question. Might this interest be recognized in the future? If you decide to recognize it, that will be your tax. So again, our understanding as a matter of fact is that the taxes were already been paid, that they're not in dispute with respect to one of these two defendants. But I think we're right, Your Honor, even on the harder case of the 2012 and 2013 returns for the reasons that I just said. I think that's the natural reading of the word yet. It's not looking to what happened in ancient history.
Thank you both. Verdugo versus Smiley and Smiley.
May it please the court, David Bloom, Kaufman, Borges, and Ryan for the Flomenhoff defendants. Your Honors, there are two primary reasons for reversal, and one of which is the items of discovery that were called for in this conditional dismissal order were well beyond the scope of this fee dispute. All right, where the discharge for cause claim asserted against my client relates to a particular client, Jose Verdugo, for a particular period of time, 8 specific litigation funding transactions between the period of, I believe, March of 07
So
till...
let me just ask you, how was there an error? How did the motion court err by requiring the QuickBooks discovery or sub-accounts in the general ledger, which the court said would suffice if the QuickBooks ledgers weren't available? None of that at all was produced. So how did the court err in that request?
So the problem, Your Honor, is the scope of it, all right? We have 2 different categories that were ordered here. One
Okay,
is...
that seems to give you a choice, at least to require your client at least to come up with one of them. There's nothing, though.
The problem is the scope of it, and that's what I'm trying to get at here. So the audit trails, I'll start there, all right? Audit trails for the 3 Verdugo ledgers, right? It calls for the production of audit trails for the entire period of the Flomenhoff defendant's representation of Verdugo from 2005 till 2009. That's beyond the scope of the relevant period here. And and the same holds true for the second category.
So what were items produced for the period in which you believe it's within the scope?
Well, this goes on to...
That's a yes or a no. Either they were or they
Our
weren't.
position is yes, but it's also not part of this particular record, only because this discovery was ordered, I believe, in April, May of 2024. The deadline was May 31st, 2024. This is beyond the scope of the record, but just, since it's being brought up now, my client did turn over everything that he has, and sure enough...
Not by that date.
It was by that date. We did respond by May 31st.
And did you submit the affidavit of compliance by June 3rd, 2024?
Yes. Unfortunately, the Schwartz Goldstone firm did not feel that it was sufficient. There were a few overlooked items, and it was completely inadvertent. But again, that's not at issue for this particular appeal. That's a fight for another day. In fact, there is now a motion pending in the lower court.
There will be.
Which there will be, of course. And our position, though, is it should never even got to that point. All right, and this brings me back to the first argument, which is the scope of the items which were called for. I've addressed the audit trails, but my client is also forced to turn over the detailed general ledger reports. All right, these are for 3 specific HSBC
Counsel,
bank
let me
accounts.
ask you this. I want to make sure, because I believe the court said you could provide, if you didn't have one thing, you could provide the sub-accounts in the general ledger, which would suffice.
The problem is that first of all, it's our position that the Schwartz Goldstone firm already has the vast majority of these items. Given
Okay, but the court was asking for it. So with regard to that, was that ever produced?
Our position is yes, it was. And again, to the extent that there's any sort of disagreement over that, this is not a willful violation of court orders. And in fact, the order appealed from, Judge Maisley even states that there's confusion over what's being called for here. If there's confusion, then there's no willfulness, and there was no basis to force my client to turn over highly sensitive, confidential records dealing with other clients, dealing with time periods that are beyond the scope of the 07-08 transactions. It was simply not proper. And again, my client's reliance on this court's decision from February of 2022, which granted my client a protective order, specifically the language of which states that documents which speak to Flomenhoff's general financial position before and after the subject loan transactions have no relevance to the material issues in this subject fee dispute, whether the client had capacity, whether Flomenhoff was aware of any incapacity, and whether the funds were misappropriated. Those are the issues on appeal. Yet, for some reason, my client is being forced in a matter of 2 weeks during a holiday break while I was away. No extensions were granted, even though we requested it. We were forced to turn over a voluminous amount of data dealing with other clients, time periods that are beyond the scope of this transaction.
The court asked specifically for the Verdugo accounts and for the sub-accounts. I keep referring to the same thing because that would have satisfied this.
Well,
I just don't.
Again, I would just refer back to the fact that A, it's our position that these have been turned over. I'm looking at the language of the May 2024 order, which deals with the audit trails and the general ledger reports. I think Your Honor is referring to sub-accounts from the language that was in the transcript, right? I'm referring specifically to the written order, which we were required to produce, all right? So I'm not certain what the court even meant during oral argument about sub-accounts. If she was referring to specific items with regard to Verdugo, fine, those were turned over, at least as far as we know. And if there's anything missing, if there was anything that was not turned over, it was unintentional. There was no basis for a punitive conditional dismissal order. Thank you.
Good afternoon. If it may please the court, Herbert Rodriguez on behalf of Respondent Schwartz, Gosen, Campisi, and Cates. We believe that Honorable Judge Maisley gave the defendants multiple opportunities.
Counsel, at oral argument, did they make the argument he's making here, that it was overbroad, that it should be limited? Did they ask the court, can we produce to you for you to review and in camera and let us know? Were any of those arguments made?
No. Let me piece it out a little bit. With respect to let me produce it in camera, no. They always made the argument, this is overbroad, it's a fishing expedition, and the like. I like to remind this court some of the history. When Honorable Tanya Kennedy was a trial judge in New York County before she was elevated to this court, she directed the defendants to produce bank statements and unredacted bank statements for these sub-accounts that Your Honor is referencing. And they made that argument. It's overbroad, it's a fishing expedition, there's confidential information. moved for a protective order, lost below. That came up to this court on appeal. This court affirmed the lower court's rulings that you must turn over these bank records. Also, if you can't produce the bank records, sign an affidavit saying that you don't have them and come up for show up at a deposition, okay? That was the ruling. We learned later during the deposition that was conducted years later that he had the QuickBooks records. And so to the extent that he said, well, you know what, I can't produce the bank records, it's so many years, I don't have them, I went to HSBC, they have a 7-year retention policy, sorry, I can't produce it. Suddenly at a deposition years later, we find out, wait a second, you have something better. What the IRS uses for financial or forensic accounting and audits, you have the QuickBook records. We went and told Honorable Judge Sharp, the second judge, can we get these records? It was already ruled upon that it was relevant and material and not overbroad and this and that and whatever. It's just a digital equivalent of the bank statements. She said, yes, you're entitled to them. Issued an order giving us all the QuickBook records, right? They said, well, again, we conferenced this case, and because this is a special proceeding, it's governed by Article 4, right? Where under CPLR 408, leave of court is required, where the court does an analysis before they issue an order as to what discovery is material and relevant, not overly broad or oppressive. In that hearing in front of Maisley, she said, you know what? Because there was a subsequent appellate division decision that limited the scope, right? That you're not entitled to the before or the after. Let's talk about the relevant time period. Let's narrow this discovery. And she issued an order saying, you must turn these QuickBooks and these audit trails in narrow form to comply with the appellate division's decision, but you still have to turn this over. They were given multiple opportunities. And when Mr. Bloom says that she acknowledged it was confusion, that's not actually what happened if you read the transcript. It was Mr. Bloom who said, I'm confused as to what you want me to produce. And the court said, you know what, to eliminate that confusion, we're gonna delineate with great specificity what you have to produce. And the order, on the face of the order that's the subject of this appeal, it lays out specifically in narrow form what they needed to produce. To date, they have not produced what I call the smoking gun. And the reason we're asking for these financial records is because it was this appellate division's court that said originally, if there is malfeasance, your fee is subject to forfeiture. And so we've been chasing these transactions, not for 2 weeks, for 8 years, through multiple judges. How many judges have to say, turn this over multiple times? And when you flout these orders, this conduct is willful and contumacious, because we firmly understand that the remedy of striking an answer is a drastic remedy and should be used sparingly. And Maisley gave an ample opportunity and said, you know what? Now we're going to issue a self-executing conditional order. If you don't produce this by the end of May, your pleadings, your claim for the fee dispute is stricken. Even after that date, and I think Your Honor brought this up, we sent letters saying, your discovery is deficient. Oh, I'm sorry, it was inadvertent. Let me give you some more. Is a smoking gun there? No. Where's the rest of it? Right? Because the allegations here is of one of malfeasance, misappropriation, self-dealing, failure to subrogate, and potentially
Was there an
conversion.
admission during deposition?
I'm sorry?
Was there an admission during the deposition that some of the money that was loaned was used for the office?
Yes. It's 7 days of deposition, 1,200 pages. In there, he says some of this money was used for office overhead. So that's actually accurate. Not only that, he calls the misappropriation of funds surplus deposit, a term that's being coined by him for the very first time. There's nowhere in the ethical rules. Right? So you can take more than what's your earmark in this account? Thank you, Your Honor. Thank you for the time.
If I may, Your Honor asked the question about at what point during the oral argument was the argument raised with regard to the overbroad scope, right? Well, frankly, Your Honor, I would submit that we didn't have the opportunity to make that argument during oral argument. However, the papers numerous exhibits that were cited, the prior NICEF filings, the various letters, and I would refer the court to pages 87 to 92, 1975, and 108 to 109, where my client repeatedly made arguments. This argument is preserved with regard to the relevance and the overbroad nature of it. And just getting back to the procedural history of this, the initial discovery request by the Schwartz Goldstone firm came in September of 2016, which were just the bank records, right? Those are the bank records. After multiple challenges, motions, appeals, ultimately this court directed these items are relevant and either produce them, or if they can't be produced, provide an affidavit. My client fulfilled and satisfied his discovery obligation in that regard by submitting an affidavit explaining why the bank records at that time, due to the passage of time, could not be produced. You fast forward a couple of years, the Schwartz Goldstone firm pivoted to trying to get the data behind that, right? The QuickBooks software. Initially, it was, I forgot the name of the judge because there have been so many, the entire QuickBooks file. My client objected and raised objections and made motions to vacate and took an appeal. And during the course of that appeal, this court determined that my client is entitled to a protective order with regard to the financial position before and after the relevant time period. If my client is wrong about that, if this court decides that our interpretation of the scope of that protective order is incorrect, then so be it, but that's not willful. All right, my client had a good faith basis to rely on that protective order to raise continuous arguments that these items are not discoverable.
Thank you.
Thank you.
Both. I'm going to call the next case out of turn, Bison Capital versus Hunton and Williams.
May it please the court, Anthony Sylvester from Sherman Atlas on behalf of Appellant. The starting point for this argument is this court's January 2021 decision, in which you substantially affirmed the dismissal of claims, but permitted to survive a sliver of a claim, namely an oral instruction that was given by client to the Hunton firm to, quote, file liens, close quote.
So just why aren't there issues of fact here about whether you breached the contract with Bison by not placing the liens on ATP's assets before they went bankrupt, as Mr. Wells alleges that he instructed or directed, asked you to do as counsel after the judgment in the federal courts?
There was no agreement with regard to the issue of filing liens. And it's clear there has to be a...
How can we decide that it's a matter of law? Because he clearly alleges that there was an agreement. And can you point to any dispositive documentary evidence that there was never an agreement to place the liens?
Yes.
Because if you don't have that, then there's an issue of fact.
Yes, to one element of the claim. But let me just say, number one, if you take a look at R243 to 247, what you'll actually see is that the Hunton firm took the position that filing the liens or doing anything with regard to enforcement of the judgment would imperil the appeal. So instead of assent here, what you have is they rejected that strategy. And it's also present in the time records in which all that's talked about, for example, is that the Hunton attorney stated, and this is at R255, evaluate some of the acceptance of benefits cases to address Ed's, quote, proposed strategy, close quote, for collecting on the judgment. Proposed is simply that, it's a possibility.
He clearly alleges that there was an agreement to place the lien. So there's two contrary views. Why isn't that an issue of fact?
Well, the allegation is he gave an oral instruction.
3 times.
But an oral instruction does not constitute an agreement. Lawyers aren't bound to act upon the unilateral instructions of their clients.
But at a
Has to
minimum,
be an
it's an
agreement.
issue of fact. It creates an issue, or it seems to create an issue as to was or was not ultimately agreed to.
Well, we would submit that the memos, which are in the record from the Hunton firm, in which it rejected that strategy as being possible imperilment of the appeal, in addition to the time records. There's nothing in any written document that corroborates anything that Mr. Wells has to say here. But separate and apart from that, and I just want to make a point, there's actually two other bedrock principles of contract law that require this to be dismissed. Number one, there are no damages. All that is alleged is in an inadmissible rebuttal report of Mr. Wells. He alleges that if the liens had been filed, it would have, quote, forced ATP, close quote, to have paid off the liens. There's absolutely no evidence of that whatsoever.
Right, but there's been no, I mean, it's a summary judgment motion. It's not a trial where all the evidence has to come forth. He certainly alleges that. And how would he prove that at this point?
Well, first of all, it's an inadmissible rebuttal report in the first instance. Secondly, it's pure speculation about what third parties would have done. It's clear in the record that there were no discussions with those third parties. So one element of a contract claim is, in addition to what your honors have talked about with regard to assent, have to be damages. And in addition to damages, there have to be definite terms. The court, and so what we have here is an oral instruction to, quote, file liens. Where were they to be filed?
The damage issues as a matter of law. Why doesn't that also raise factual issues?
The entire submission on the issue of damages is a rebuttal, so-called expert report authored by Mr. Wells. His position is that if the liens had been filed, it would have, quote, forced ATP. But the point is, there's no evidence in the record about what the third parties would have ever done.
But we don't know that yet. That's what my colleague keeps saying. It's at a point where there hasn't been any discovery yet. So we don't know these issues, and he's making a viable claim, is he not?
Well, the discovery's closed. The third parties have not testified or provided any evidence about what they would have done. And you also have, a fact that in the bankruptcy, there also was a clear demonstration that there were billions of dollars ahead of secured debt that was already in place. So as when you put that together, the simple fact is, and we have provided in the record the report of our bankruptcy expert, there simply would not have been any recovery here. And again, with regard to the rebuttal report, as the court below pointed out, it's not admissible in any event on the main case. Now,
Thank you.
I'm sorry, thank you.
Rebuttal time.
May it please the court. I'm Matthew Press for the respondent and cross-appellant Bison Capital Corporation.
Is all discovery complete?
Yes, Your Honor. Discovery is complete. Your Honor, Justice Schechter correctly found that after discovery, Bison adduced substantial evidence supporting the breach of contract claim, that including evidence both of Bison's instructions and Hunt & Williams' agreement to place liens. She said, quote, "The details are only more now than they were before," and that was referring to the court's prior decision. Now, as we demonstrated in the brief, there was a February 3, 2011 retainer agreement. That agreement required Hunt & Williams to continuously represent Bison through the payment by ATP pursuant to an agreement or a judgment. And all of the judgment protection and enforcement work necessarily would fall within that agreement. We submit that the agreement itself committed the Hunt & Williams to file liens and take other actions to preserve the judgment. But separate and apart from that, the trial court found that there was evidence of an oral agreement. And as you've seen in the record, the court has seen, it isn't just some naked allegations by my client, by Mr. Wells, the president of my client. There's ample evidence in the billing records and the emails of Hunt & Williams himself of Ed's strategy of enforcing the judgment. And that strategy was conceived by Mr. Wells, who, as the record reflects, was an expert in the oil and gas industry. He understood very well all the pressure points on ATP, and he conceived of the strategy of using the liens, the filing of liens, to force an earlier payment of the judgment. And that was based on his understanding as a percipient witness that ATP at that time relied on something called overriding royalty payments. The overriding royalty payments required that there be no impairment of any kind on the oil assets of ATP. And so the mere filing of a lien would have forced the payment. And the point here, what I heard my colleague say is that Mr. Wells' statement was in a rebuttal expert report. But Mr. Wells, as we stated in our brief, that Mr. Wells also was a percipient witness, and the evidence is that this was the very strategy that he had conceived of at the time. And so his evidence and testimony about how this all would work, the mechanics of forcing the payment, is all something that he's entitled to testify to as a percipient witness. We also filed a rebuttal expert report in order just to put the other side on notice of some of the facts concerning the overrides. Now, I'd like to also state that while the trial court was correct on its ruling on the summary judgment motion, the court did err on its spontaneous finding that an unpled affirmative defense of set-off could just be concocted by the court. Hunt & Williams is one of the nation's largest law firms. They're big boys.
Did you cross appeal?
We did, Your Honor. There's a cross appeal on this point. Hunt & Williams is a big boy. They could have pled an affirmative defense of set-off. They didn't. They waived that. They could have moved for leave to amend. As we said in our papers, there was substantial prejudice to Bison. Bison, once the malpractice claims were dismissed, there was no need for Bison to get into discovery on the details of the deficiencies of Hunt & Williams' representation. There was Mr. Steinberg.
There's no set-off, and your client gets the money. Wouldn't that be like a windfall for him, and in that he would not have to pay any legal fees? He'd just get all of that. I mean, the original idea was that the legal fees would be taken from whatever amount he got. So now he would just get it all, and they wouldn't get any legal fees.
Your Honor, I think what this comes down to, I understand the argument, I certainly do. I think the answer to that is Hunt & Williams, they shoved this contract down Bison's throat in order to coerce Bison into signing an agreement, because they claimed that they weren't going to file a post-trial brief afterwards. They shoved this down his throat. It has plain language.
They were owed a lot. Weren't they owed a lot at that point?
Well, I think that it was about $600,000 and change, and I think the answer to this question is they prepared this contract. The contract says that if there isn't a payment by ATP, that their fees are not owed, and I think they have to live by that. Thank you, Your Honor.
Yes, thank you. Briefly, with regard to the cross appeal, 8 times in the main brief, the decision was described as sua sponte. 5 times in subsequent brief, it was described as spontaneous. I think you heard it said here today. If the court agrees it's sua sponte, then the cross appeal should be dismissed under Scholes. However, if the court determines it's going to decide it, then we're in an abuse of discretion standard with the trial judge, who is our trial judge, who made a determination under CPLR 3025 to conform the pleadings to the proofs. And that is entitled to deference, and we submit there has not been a showing of prejudice. The underlying facts have been in the record, and in this case, since 21. With regard to our appeal, the court below clearly felt it was bound by the decision of this court on a motion to dismiss. The decision on a motion to dismiss should not control the outcome of a case once the record is developed. And she certainly did not make the sort of findings that I heard that she is said to have made. She felt she had handcuffs on, frankly, because of what this court had found in 2021. We submit that the time for a different standard is to be applied, and the summary judgment standard would require, we believe, this court to find that there was, in fact, we met our burden to show there was no oral agreement, and in fact, Bison had not met its burden to show that, in fact, there was. The evidence in the record with time records, with the fact that there's a memo that says this is an incredibly risky strategy, demonstrates there was no assent.
Thank you. Did you want to respond?
Just on the cross appeal, there was significant prejudice by Justice Schechter coming after the counterclaim had been dismissed by the counterclaim of Hunt and Williams to sort of manufacture this new set-off claim. And I understand the arguments that perhaps there would be a windfall to Bison, but what we have to look at is procedurally. Where Bison finds itself now is it's going to have to go to trial, and it wants to argue that the services of Hunt and Williams were deficient in order to fight against a set-off. Okay, but because there was no set-off firm defense throughout the discovery period of the case.
Counsel, you can always ask for permission to reopen discovery, can you not?
Your Honor, I suppose we could, but it's not where we are right now is that at this point in the case, we do not have, I doubt very much the judge would let us now subpoena a lot of third parties like Mr. Steinberg and cross-examine him to establish the deficiency of the services and thus that the Hunt Williams bills were not justified. And so we relied on the fact, and I'll conclude quickly, throughout the case we relied on the fact that it was crystal clear that because there had been no payment by ATP, there could not be any amount due. And this set-off was a surprise that came after the fact, after we had missed the opportunity to take the discovery we would need to defend ourselves from this set-off claim, and that's why the set-off would be inappropriate. Thank you very much, Your Honor.
Thank you. Thank you both. 5 Star versus Trustees of Columbia. Justice Rosado is recused from this case.
Shall I proceed?
Just a minute. Wait till your colleagues are seated. Okay.
May it
Yes.
please the court, my name is Andrew Richards. I'm with the firm of Kaufman Dolowich, attorneys for plaintiff appellant 5 Star.
So this extra work claim
Yes.
Has to be in writing. It's strictly enforced. You rely on an email that is not a writing. What do you have to support your claim for the extra work?
Well, we've submitted a lot of documents with the pleading. We've submitted documents. We submitted these supplemental answers derogatories on the date that.
Right, but is there any writing that
Well, we have to do
establishes
ESI.
that
That
you're
was one of the
entitled?
pro-
Don't
I'm
speak
sorry.
when I'm speaking, because then I can't get it out, and, we want to make sure the record is clear, even if you know what I'm going to say. What clear writing is there that you have sent to them you two have communicated that an extra there is an extra work claim?
Yes, well, the first thing we have is in the record is the September 2018 memo between Lend-Lease and 5 Star where they were talking about the extra work claims.
That's not a clear writing as is meant by the contract.
Well, the clear writings can be in various forms. Many courts have accepted emails as notices of extra work claims. We try these cases all the time. No one's writing letters anymore. Everyone's using email. And that's how it goes back and forth. It's very fast that way. It's much faster than when I started practicing law and I still found carbon copy paper.
It has to be clear.
It has to be clear, 100%. And we also, as we set forth in our brief, we need ESI to be done. And that's what kind of things lopped off years ago, because the parties were negotiating ESI terms, which we put in our supplemental answer derogatories, we need to do.
So where is it clear in the record that that the extra work claim is defined and you've expressed what it is?
the extra work claims are in the documents that were submitted with the supplemental interrogatory answers. They were in there. And we have to find more. We gave what we could give. As I said in the papers, we sent someone to the client sent someone to the warehouse because we weren't doing the ESI yet because we didn't agree on the terms with the other side.
Why did you have to agree on terms for the ESI? Most of the searching would have been of your own record, so why wouldn't you have known what to search for without getting an agreement about that?
Because we were working on the agreement and we did not want to spend the resources and the time and the money to do it twice.
But
We'd have to do it
your
twice.
obligation was to respond to their discovery. If you have documents and you want to search for the relevant documents, why couldn't you just search for the relevant documents?
Because that's not the way the court instructed us to do in the court below. The court below said answer the supplemental answers to interrogatories, then you'll agree on ESI terms and we'll go forward. That was what we were supposed to do.
That didn't prevent you from...
You're trying to prove your extra work.
That's correct.
So you would think that you would be going to the warehouse, getting all of the backup for that,
Correct.
right?
That's right.
And then it was 6 years. And
Well,
it
it's,
wasn't
it's really 3 years.
Mhm.
I know it still sounds bad.
There was a lot of
I
delay
know.
before. There was a
There
lot
were
of
two
delay.
motions.
I
hear what you're saying.
Counsel, I have a question, so stop talking. There was a lot of delay before that 2021 period, and it seems that what you have established, even with all of this time, is a simple March 30th, 2018 email with regard to any sort of written notice. That seems to be all there is right now.
I'm sorry.
Go ahead.
There are documents attached to the amended complaint that were submitted, which that's in the record as well. So there are some documents there, but we're not here on the veracity of the claim itself. We're here because the judge dismissed it for failure to prosecute without a motion. There was no motion for failure to prosecute, which if defendants thought we abandoned our claim, you do that. And honestly, in my years of practicing, usually you get a conditional order first, saying, hey, you have 30, 45, 60, 90 days to do X, Y, Z, or you're gone.
Yeah, but
that didn't happen either.
But we are sitting here after all of this time,
Mm-hmm.
and still, I don't hear you saying anything concretely with regard to what you have to show that you have something in writing at this point that is clear, that establishes this extra work claim. That's just one of the things. I don't see
understand what
anything
you're saying,
here.
Your Honor, but I disagree to a certain extent that
Okay,
there
so
are.
let me move on to the next claim. Do you agree that there is an outstanding amount of money that they owe you?
Yes,
And what is that amount?
$855,000 and change plus prejudgment interest.
Okay, would that be 855,000 and the change would be 644? 8,555.
No, I'm sorry, 855,000.
855,644,
I think.
644. Is that the amount that you claim that you're owed?
That's the amount we claim is owed on the contract balance, not the extra work claims. They're separate.
I'm not talking about
Okay,
the extra
and
work.
they agree to that number. It's all in the record.
So that is it. Is that it? Is that the amount? That is the full amount that they owe you. You agreed that that is the full
On the
amount.
breach of contract claim, yes. The contract balance, yes.
But then there was an email in which you said that you are retaining the right to claim that it's more than that, correct?
Because someone did something stupid in the
So
email.
you're now saying that was a mistake?
It's 855,
They should have
644.
So they should have disregarded that?
No. We agreed that that's the money we owed in the email. I think it was Andrew Cow's email. We agreed that's the number. We agreed with it right here. I'm on the record. I agree with it right now.
Okay, thank you.
Good afternoon, may it please the court. James Terry of Zetland de Chiara for Respondent Columbia. I think the
So
court.
is there any question that it's $855,644 that you owe Five Star?
Yes. With respect to that, there is.
Yes, there is no question, or there is a question?
We agreed on the quantum as the court below directed us to do. What we did not agree was on 5 Star's entitlement or Columbia's liability. As was pointed out actually in the Lend-Lease brief, there is a counterclaim that serves as an offset to the contract balance claim. So the representation in the briefs that we acknowledge liability with prejudgment interest and all of that is yet another falsity among the many falsities that
I'm
appear in this
looking at
case.
Vincent Camacho's email. Who's that?
Mr. Camacho is Lend-Lease's counsel.
Okay.
Right?
And yes.
Sorry.
And so I'm looking at this email of March 12th, 2021, when he indicates that the outstanding contract balance is $855,644.
That is the outstanding balance. Whether or not we are liable to pay them depends on whether or not it is entirely offset by the counterclaim. So we did what the court below asked. We agreed on the quantum. That's your contract balance, that exact amount.
And what was
down
the
to penny.
counterclaim?
Pardon?
What was the counterclaim?
Oh, the counterclaim was for damages that Columbia incurred because of their lateness, 5 Star's lateness. We had extra work.
Lateness in what?
The follow-on contractor had to do. 5
see.
Star was the core
I
and shell.
understand. I understand. You're saying they were late in completing the work. You had to get somebody else, or
Well, there was
coordination of.
pretty close. There was already another contractor who was going to do the interior work. They had to start late and do additional work because of 5 Star's lateness on their portion of the work, which was the electrical for the core and shell, the exterior.
And was that quantified at some point? Was that amount quantified at some point?
You're
saying that you agree that-
I'm
I'm
sorry?
sorry?
It's in the counterclaim, but discovery was not taken on the counterclaim because the court below directed us to focus on the extra work claim as we did and get.
A ballpark. I mean, do you have any ballpark of what the
It was
counterclaim?
over $1 million.
Okay, so as compared to the 800,000, you had a counterclaim of over $1 million, is what you're
That's
saying?
correct. And that's clearly in our
Where is that in the
pleading.
record? Is that in the record?
It should be in the record, and yes, and it's part of the argument that that
Can you
was
give us
held
some
up.
idea where it is in the record? Maybe your colleague can. Okay.
Did you make a motion to strike the complaint? Was there a motion?
We made yes,
So it wasn't sua sponte?
we made the motion to strike the complaint exactly,
Yeah.
and right on several grounds. I mean, there was the fact that they did not make timely discovery. There was rampant dishonesty when they were called on the carpet by the court in June of 2023. They affirmatively misrepresented to the court below what the status of discovery was. The court below noted that they were engaged in evasive conduct. I think he used the term kicking the can down the road. And there was the fact that there were no fewer than 3 discovery orders that were flouted throughout. So,
Thank you.
thank you, appreciate it. And we'll get the citation for you. Okay.
Hey, please the court, Daniel Wright. I'm an attorney with Milburn Macris on behalf of defendant respondent Lend-Lease. I'm also a graduate of New York Law School, so say hello
Not
to
too many of them
the
left, but
remaining the
at least a
remaining New York
couple.
Law students that are here. I was in your shoes not long ago. I could not find, I didn't have enough time to search in the papers for that citation to the record that you were requesting. But as to the issues that we've covered so far, as you know, our papers mirror each other largely, so I won't belabor the same points. I just have a few key issues that I'd like to touch on. First being that in this appeal, this is a lower court order that wasn't a short form order. This is a lengthy order that clearly the lower court went into very, very detailed search of the record, looking at 4 years, 8 good faith correspondences, 3 court orders, and did a full breakdown of each essential element related to the relief that was sought of striking the complaint. and including that breakdown, the standard of striking the complaint does not require prejudice. It only requires willfulness. And Five Star admitted it could perform the search without ESI, and it, in fact, did so eventually, showing that they never needed the ESI to perform the search. They just didn't want to perform it because it was costly and time-consuming. In the same breath that they are alleging that there is no prejudice, they also claim that in performing the search, they had difficulty performing the search because some of their employees had moved on to new employment or had died. So the misrepresentations by Five Star throughout the lower court and on appeal are numerous, and for these reasons, we respectfully request that you affirm the decision of the lower court.
Thank you.
Thank you.
Just like to address 2 points. One, the court asked for the contract balance. It was at that time they should have said underneath, this is the contract balance, but we have counterclaims. That was not what we were supposed to do. We were supposed to say what was owed to Five Star. That's how we interpret it. No one had an asterisk in the email saying, but hold on, we have counterclaims, so we don't owe you this money. That was never done. Two, the court, defendants did not just bring their motion to strike on their own. They were invited to do so by the court. It was kind of like the court saying, hey, make a motion, I'm going to get rid of this.
They did make a motion.
That's correct, they did.
You said in your argument earlier that it was sua sponte. That's not correct, right?
Well, no, it was, I didn't say it was sua sponte. I'm telling you now that the court said, I think you should are you going to make a motion? They said, yes, it's very clear. If I misspoke, I misspoke. It wasn't sua sponte. It was basically, they didn't go there. They didn't make a motion for failure to prosecute. They did not make a motion for a conditional order. The court said, well, I think we should bring this to a head. And my point is, the optics aren't good. I get it. I do get it. But it's too drastic of a remedy here at this point. I know 3 years may seem like a long time. However, the court's cases go on for many years. And there are reasons why we didn't do much more in those 3 years that I really can't get into because I'm fearful of attorney-client privilege. So I didn't put anything else in the papers like that.
So none of that is in the record as to why it took so long.
Well, the only thing that's in the record is we did look at the warehouse, look for some documents, because we didn't have the benefit of the.
But there are some other reasons that you're not willing to tell us.
That's correct.
Okay.
But I'm saying, but delay alone is not sufficient. Prejudice is a factor to be considered. There's no affidavit from anybody from the defendant saying we threw out our computers, we threw out our servers, we can't get a hold of anybody. So there's no prejudice to them whatsoever. Yes, 3 years went by, but that's the only thing that's wrong here. I do understand courts need to move cases along, but this was just too drastic. Thank you.
Thank you. Thank you all.
Please rise.